Hey, Judge Porter.
Good morning. How are you, Judge Kim?
I'm good. All right, so we have the CPS stuff, and then I'll do original detention hearing at 10:30. I'm going to stop the CPS trial about 10. Original detention hearing about 10:30, and then when it comes to 10 days, I'll pass off for you so I can step down and have lunch, and then pick up. I'm going to schedule the CPS hearing to go back like at 1 o'clock.
Sounds good.
Just leave it running, and that way all the attorneys from the first detention hearing can just come back to the same room.
Sounds good.
All right, I think it'll work out tomorrow. I don't know if Judge Terry got her own code yet or not for tomorrow. But if not, you may have to set up the log on for her or something.
Okay.
So I'll be running the CPS trial straight through tomorrow, so y'all can do the detention hearing separately.
I know that there is something set up for tomorrow, but I'm not sure what it is.
What do you mean something set up for tomorrow?
There's a meeting already scheduled for tomorrow on Zoom.
Oh, is there?
Correct.
Okay. Okay. All right. So. Okay, but yeah, if she can go ahead and set that up, and then tomorrow, so this CPS trial can go straight through, and the county theoretically should be providing us new computers today.
Yay! I'm gonna come visit with you about one of the detention hearings.
Okay.
But I'll do that in person. I'll be down just a little bit.
Sounds good. I'll be here.
What time are detention hearings now?
Detention hearings are at the same time. They're at 10:30.
1:30? 10:30
yes.
every day?
Yes, Miss Abels. Yes.
Okay.
Right now we're here there's a CPS trial. They'll start in the morning, and then we'll recess about 10. Detention hearings about 10:30, and then resume the CPS trial about 1 o'clock.
Okay. I have one tomorrow. My detention hearings tomorrow.
Oh, okay, good. That one, you'll get a separate link for that one.
Yeah, he's not going home, and he knows that, and he's cool with it.
Okay.
He's going to, I think. I hope.
I'm kicking out the Zoom sessions for the detention hearings because it's just another window. We can reconnect at 10 o'clock.
You do them all. Are you doing that right now too?
The what?
Detention hearings?
No, they're at 10:30.
Oh, okay. That's what time I put in my calendar. I just wasn't sure.
Yeah, that's correct. All right. While waiting for people to join, I'm just going to go ahead and stop the video from this side, but the room will be open.
Okay.
Hello.
Hello.
Hi, this is Gwen Darby. Who am I speaking to?
Oh, this is Anthony Avery, the principal at Hazel Harvey Peace.
Oh, how are you, Mr. Avery?
I'm pretty good. How are you?
Good. Hi, Laura.
Hi, can you see me?
I can see you. This is Gwen Darby, but I can't see. It seems like Kathleen and the other people are having a conversation. Oh, there's Kathleen. Hi, Kathleen. This is Gwen.
Hi, Gwen. Don't look at my messy daybed back there.
Hey, Tracy. Mr. Avery is also here with us.
Okay.
There's
Hey, Gwen.
Madison. Madison's here too.
All right. Good morning, everyone.
Good
Good morning, Your Honor.
All right, so this is a first for us. As far as I know, the first full trial is being done on Zoom. Let's see. Ms. Shank, just so you know, she contacted the court. She represents the unknown father. She is having personal health issues, so she submitted a ad litem report. Does everyone have a copy of that?
I believe so, Judge.
Email Stephanie now asking me to send it.
I got a copy, Judge.
Okay.
Trying to open it.
Espinoza has one. Ms. Abels, did you have a copy?
Judge, I have a link, but it's not letting me.
A link or an attachment?
Well, it comes in on a shared scan April 17th. And then when I click open, it's not letting me open. Let me try on a different.
Okay, let's go back. So does Ms. Ganoza and Ms. Abels, do y'all have a copy of Ms. Shank's ad litem report?
I'm looking for it right now.
Okay. All right, great. And then I guess we need the attorney for the state.
I think she's in the waiting room, Judge.
Oh, Ms. Neighbors.
Yes.
Hello, Ms. Neighbors. Oh, she's connecting audio.
Judge, I don't have an email from her on the 17th.
Okay.
She emailed us on April 20th, but she scanned
Well, I don't need to know the dates. I just need to know if you have it, or if you don't have it, that's fine. I'll have Stephanie email it now. So Ms. Abels, you do not know if you have one or not?
I do.
You do have it. Okay, Ms. Ganoza, do you have it?
I do.
Okay, Ms. Neighbors, do you have Ms. Shank's ad litem report?
I might. Sorry, Judge, I'm just getting connected to the.
No, it's all right. She's just, Ms. Shank has some personal health issues. So she filed a ad litem report and it's not appearing and it's excused by the court. I just want to make sure everyone has a copy.
Kim, she emailed it to
Yes,
us on the
I
20th
do
of
have it.
April.
Okay.
That
Mhm.
helped.
Yes.
Ms. Darby, Ms. Evans, y'all are the CASAs on this case?
That is correct.
Yes,
Great, wonderful. Who is Ms. Darby?
The one
I'm
that-
Gwen Darby.
Gwen, okay. All right, your name only showed Gwen. All right, I'm just curious who everyone else says. Miss Evans.
I'm Miss Evans.
Okay. All right, and then Miss Williams of the department. Anthony? Do you have a last name, Anthony?
Avery.
Okay. And your role is?
I'm the principal at Hazel Harvey Peace Elementary.
Okay, so witness?
Yes, Your Honor.
Sure.
Okay. And then Miss Levy?
Hello, I'm Sharon Levy. I'm the case manager at Hazel Harvey Peace
Hazel Harvey Peace
Elementary School.
Elementary School. Okay, so you're a witness also.
Yes,
Miss Webb,
Yes,
what is your role?
I'm his previous behavior specialist.
Okay. Oh, so and also a witness?
Yes, sir.
Okay. And there's Miss Castro. All right, so I have a question before we get started. Is anybody going to invoke the rule?
I'm sorry?
Before we get started, is anybody going to invoke the rule?
Yes,
Who said yes?
I did, Judge Key.
Okay. All right.
And Judge, I'm waiting on one more witness. I actually subpoenaed 2 more, but I haven't heard from them.
Okay.
But I did hear from his former foster mom. That's who I'm waiting for. She
When the
did
rules
text-
invoke, you'll have to make sure that your witnesses don't enter and hear testimony. Okay. All right. So at this point, all right, are all the parties ready?
Judge, I'm actually still waiting on my
I don't know who is
permanency
I.
specialist,
Who is I?
as Kim Neighbors.
Okay, I'm sorry. Thank you. Okay, Miss Neighbors, you were saying?
I am waiting on my permanency specialist. I think there was some confusion about whether or not we were starting at 8:30 or 9:30. So I'm trying to get her on this call right now.
Okay. All right, let's go ahead and let me take care of the other stuff first then. Okay. The court, Kelly, are you ready? Okay. So the court will call cause number 323-107543-18. All right, this is styled in the matter of Jeremiah Alexander Castro. We are here for final trial on the merits for this matter. Now, before proceeding with trial, I would like to take care of some housekeeping matters. First of all, the court take notice that this proceeding is an essential proceeding because of a pending deadline. And so we are proceeding under the guidelines set by the Supreme Court of Texas and the Court of Criminal Appeals for the state of Texas, which dictates that any online or any proceedings during this coronavirus pandemic shall not be in court in person, but broadcast using Zoom, which we are doing so. The court reporter, Kelly Peltier, is here in the courtroom making a transcription of this record. All right, so we do have in the Zoom meeting a couple of witnesses, and I want to go ahead. So this will be, I guess, Anthony Avery. Did you say? I'm sorry, it only shows your first name. Could you let me? I'm going to just change your name.
Okay.
Gwen, what is your last name?
My last name is Darby, D-A-R-B-Y.
Thank you. All right, so we do have some witnesses here in the Zoom session. So to the witnesses, so Mr. Avery, Ms. Levy, and Ms. Webb, there's something called the rule. What that is in the state of Texas is to To ensure a fair trial, one or any of the parties or the court can invoke what's called the rule. And what that means is that it prevents any witness from hearing or observing the testimony of any other witness. This is to ensure that one witness's testimony may not be changed or altered based on the testimony of other witnesses. It's just a matter of kind of keeping everyone blind up until the point they testify. And that's just to make things as fair as possible. That way there's no particular advantage to the first witness or the last witness. And you can see how that may affect things in certain trials. So the rule has been invoked. So at this point, what I want to do is for Mr. Avery, Ms. Levy, and Ms. Webb is to go ahead and swear you in as witnesses to start the process. And then afterwards, I'll excuse you from the session so you're unable to see or hear what's going on. Ms. Gonoza will have to inform you of when you'll be needed again. So you would be able to enter the Zoom session at that point. Okay. Do you understand the process so far?
Yes.
Okay, good. All right, so Mr. Avery, Ms. Levy, Ms. Webb, if you could raise your right hands for me. Do each of you solemnly swear that the testimony you're about to give at this cause currently at trial, that you will tell the truth, the whole truth, and nothing but the truth, so help you God? I need an answer.
Yes.
Oh, I do. Yes.
Okay, thank you. All right, so each of you has been sworn in, so your process has started. Now what we need to do then is stay in contact with Ms. Gonoza, however she reached you in the first place, and then she will let you know, kind of anticipate about when you need to be prepared. Let's see, that's the best way. She will let you know when you're ready for a phone call, if that makes sense. So whenever she calls you, it won't be at that moment, but it'll give you an idea. She can give you a window of when you would be needed for testimony. That all depends on, since you're witnesses by Ms. Gonoza, this will be after, when she presents her case, this will be after the state of Texas presents theirs, okay? But she can contact you to give you a timeline or time frame so you can go about your business in the meantime, okay?
Okay, thank you.
All right, thank you very much. All right, Ms. Dye.
Yes, sir.
Yes, how are you related to this cause?
I was Jeremiah's foster mom.
Okay, so are you a witness?
Yeah,
Okay, who subpoenaed you?
Miss Gonoza asked
Okay.
me to.
Okay, did you hear what I was saying?
According to Illinois Legal Aid Online, to
That's
subpoena.
I guess, all right, so Ms. Dye, did you hear what I said to Ms. Levy, Ms. Webb, and Mr. Avery?
I heard a little bit of it.
Okay, I'll start over. So in the state of Texas, well, Ms. Gonoza, how many more witnesses do you anticipate coming?
Judge, I was waiting on DFW psychological, unless Miss Neighbors and Miss Abels will stipulate to she's the custodian of records. That's the only person I have left. It was 1 page of records. I sent it to him this weekend and asked him whether or not she needed to be here. So that's the only one that I'm waiting. And then the other 2 were subpoenaed, but they have not made contact with me as instructed.
All right, so Ms. Dye.
Yes, sir.
So what we have here is we're here for a trial and you're called as a witness for this matter. And so the rule has been invoked. What the rule is a law in Texas when there's witnesses in a trial to ensure a fair trial for all the parties. One party can invoke the rule to dictate that the witnesses may not hear or observe each other's testimony.
Yes, sir.
With that, and you can see how the first witness in a case or the last witness in a case may or have an advantage or disadvantage based on what point they testify if they can hear each other's testimony. So to ensure a fair trial for all parties, the rule can be invoked, and it has, of which you would be excluded from hearing any other witness testimony and discussing any testimony until the trial is concluded. Okay. So what I'm going to do is I'm going to swear you in first. So if you could raise your right hand for me. You solemnly swear the testimony you're about to give at this cause currently a trial that will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Okay, thank you. If you can lower your hand. All right, so at this point, I'm going to excuse you from this proceeding so you cannot see or hear anything that's going on. Ms. Gonoza will let you know when you'll be needed. She'll give you a time frame of when to be available by Zoom, but I don't think it's going to be any time, in the next hour or 2, so you'll be free to go about your business.
Okay.
But it's really up to you. Whenever Ms. Gonoza tells you that you need to be here, then you need to be here available. Okay?
I do have one question.
Yes.
I am to Zoom. So do I just stay on this after you excuse it, or do I have to log back in later?
You will have to log back in later. Ms. Ganoza will let you know when you need to log back in.
And it'll be the same link that she sent me before?
Yes, it'll be the same session code. That won't change.
Okay, I appreciate you. Thank
All
you.
right, thank you, Ms. Dye. All right, Ms.
I see Ms.
Let's see.
Garcia.
Yes, so I guess, there we go, Ms. Webb. Okay, who is Crystal Garcia?
Probably the custodian of records from DFW Psychological Judge.
Your Honor, actually, Crystal Garcia is the supervisor for Karen Soto.
For who?
Karen Soto Lopez, she is the permanency specialist with OCOK.
Okay. Is she a witness?
No, I anticipate she's probably here to just observe.
Okay, just when there's so many windows open, it makes it difficult. So if people are here just to observe, there's a YouTube link. I will send it through chat. All right, so I sent a YouTube link in the group chat to everyone. So if somebody wants to simply observe, they can go to there and they can watch the proceedings through the live of this. Otherwise, it makes it very difficult to see who's talking or who's doing what. So, all right, so if you're not, I guess at this point, if you're not an attorney, who is admin?
I believe that's Vanessa Judge from DFW
Right.
Psychological.
Sorry, it's Celinda with DFW Psychological.
Okay. All right. All right. So could you change your name in Zoom so we can?
Yes, sir.
Thank you.
Sorry, this is the first time I've been on. I'm trying.
All right, it's not a problem. It's the first time for us too.
Okay, let me see if it.
All right, so Ms. Neighbors, who is your client today?
I'm sorry, what was that?
Sorry, Judge. My client is Karen Soto Lopez.
Okay.
She's the permanency specialist with OCOK.
Okay. So, all right, Ms. Dye, if we can excuse you from this.
Okay.
Yes.
Judge, log out. I'm sorry. I don't know what to do. I've never.
No, that's right. Yeah. So you just, I'm not sure how it looks, but yeah, basically you log out, but do be available to Ms. Ganoza. Oh.
Okay.
Okay.
All right.
And then.
That is not logging out. I'm sorry, I'm trying to log out.
No, that's right. I think you hit stop video and that just stops the screen. But I think you would just log out. But make sure you're available to Ms. Ganoza so you can be brought back in when you're needed.
Okay, I just don't see where it says to log out.
Just hit, you should hit leave meeting at the top left.
I see it now. Thank you. I see it now.
Ms. Williams is Ms. Soto supervisor?
I am the CASA supervisor.
You're the CASA supervisor?
Yes.
Okay. So then the question is, at this point, so Ms. Darby, Ms. Evans, and Ms. Williams, are y'all comfortable observing this through YouTube, the live stream broadcast? There's a 20-second delay, but otherwise you see everything. Is that okay for you? Or, I mean, I certainly want to be accommodating to CASA, but three of the windows makes it confusing, especially since the court reporter has to keep track of who's talking when things are being spoken. Would that be overburdensome for you guys to watch YouTube, watch this live stream on YouTube? And that way, if you were needed as a witness, we can still reach out to you and bring you as a witness.
Okay, I saw you send the link to go to that, but I don't know where it went.
There should be on the right a group chat. You see that group chat on the right?
No.
No, we don't.
No.
In the top right-hand corner, there should be 3 little dots. If you tap on the dots, it will come to a group chat.
I'm sorry, I see 9 dots, but I don't see 3.
Tap on them.
I had to take it out of gallery view.
Okay. I can see the link that Judge Kim sent, but when I press on it, it doesn't do anything.
You may have to cut and paste. It may not come over as a link itself.
Gwen, where did you see it? I don't see it.
Actually, it was down in the right-hand corner of my screen. I saw the 3 dots. I touched on that, and then I touched chat. But I can't get it. It won't let me copy or paste it.
So,
Oh, here's the, okay. No, it doesn't do anything when I touch it, so.
Can someone email it to our CASA supervisor and then she could forward it to us?
right. I don't know. Let's see. What I'm going to do is ask the coordinator to email this YouTube link to everyone she emailed the Zoom information to.
Mm-hmm.
That way that can get to everyone.
I think I can email it, Judge Kim.
I'm sorry?
I think I can email it.
Okay.
So now we just close down this this Zoom version and wait for the email, correct?
Well, why don't you wait for the email first? Because I want to make sure you can watch. I don't want you to lose all contact with us.
Okay.
All right. So at this point, we're going to go off the record because we're just kind of housekeeping.
Mm-hmm.
Sorry.
It is not allowing me to copy it.
Try highlighting it and pressing Control and C at the same time. And then go to a web browser and press Control V to paste it.
I did that, Judge, and it's for some reason it's not letting you it's not letting me copy it either way, either with the mouse or the Control C.
Judge, if I may, you can just click on the link and it will open the actual YouTube page. And then you have the YouTube page open, and then you can also copy that link from the top of the YouTube page, but you have to actually click on it. You can't copy and paste from a Zoom chat.
There is no hyperlink on it.
Mine's opposite. I can Control C and Control V to copy and paste, but I can't click on I don't have a link. I guess it depends on the platform.
If I tap on the top of mine, it says live on YouTube. If I tap on that, it gives me a streaming link. It's a hyperlink. I mean, I have to tap, I'm on an iPad, so I have to tap the screen and it says live on YouTube. I tap that, it says copy streaming link. It's a hyperlink. Right.
Stephanie was able to send the link. I can send it to them.
I mean, I have to tap, I'm on an iPad, so I have to tap the screen and it says live on YouTube. I tap that, it says copy streaming link. It's a hyperlink. Right.
Stephanie was able to send the link. I can send it to them.
I mean, I have to tap, I'm on an iPad, so I have to tap the screen and it says live on YouTube. I tap that, it says copy streaming link. It's a hyperlink.
Okay, so somebody has two two sessions going on in the same room, so we're getting that feedback. If we can ask them to have them remove the second one. All right, so Ms. DeBello. All right, so you're called as a witness for this proceeding. And so, I guess okay, so you're called as a witness, Ms. DeBello, you are called as a witness in this proceeding by subpoena. And so the rule has been invoked. What the rule is, it's the law in Texas that prohibits one witness from hearing the testimony of any other witness. This is to ensure a fair trial for all parties. So you can imagine how there may be advantage or disadvantage for a party who is testifying first or last if they could hear the other witness's testimony. So because the rule is invoked, what I'm going to do is swear you in as a witness. So if you could raise your right hand, first or last, if they could solemnly swear the testimony you are about to give at this cause currently at trial, that you will tell the truth, the whole truth, and nothing but the truth, so help you. All right, you can lower your hand. So at this point, I'm going to excuse you from this session. You need to stay available by Ms. Ganoza, and she can give you a time frame of when you should be available for this court proceeding. At this point, I'm going to excuse you from this session. Lose the link that you had. Ms. Ganoza, and she can give you that. But at this point, if you can exit the Zoom session, just make sure you're available to Ms. Ganoza. Okay?
Thank you so much.
Thank you. At this point, if you can exit the Zoom session, just make sure you're available to Ms. Ganoza. Okay?
Thank you so much.
Ms. Evans, do you have YouTube?
I have it, but the audio is terrible.
Okay. Can you mute your Zoom session? Because we're getting the rebroadcast of your broadcast, if that makes sense. Mute your Zoom session because we're getting the rebroadcast.
I clicked out of it, I thought.
Mute your Zoom session because we're getting the
Clicked out of it, I thought.
All right, so Ms. Williams, are you able to view the YouTube broadcast? You're on mute. Oh, there you go.
I'm able to view it from YouTube.
Okay, great. Then do you mind if you can
Yeah.
watch it from YouTube? That way you can see all the proceedings. I want you to see all the proceedings. It's just, it makes it much more difficult for the court reporter to see who's talking.
Okay.
There's additional windows. Okay.
All right, thank you.
Thank you. And then Ms. Evans, is your YouTube working better?
Well, I don't have the video now, but I can hear you.
On YouTube? So the YouTube was running or not running?
I can hear you, but I cannot see you. But I've clicked on something else and it's acting like it's trying to open, so.
Okay. Ms. Darby, are you able to view the proceedings through YouTube?
I cannot see.
I'm not able to get them at this time. I'm waiting on the email to come from the CASA supervisor.
Okay.
Gwen, I think I also tried to email you the link.
Okay. Okay, I got the link, so I'm leaving the Zoom.
Thank you. Okay, so we're down to necessary parties, is that correct?
Yes, Your Honor.
Great. Okay, are we all ready to proceed then?
Yes, Your Honor.
Okay, so I've already called the docket. At this point, so or we'll take notice that the dismissal date for this matter is November 8th, 2019, with an extension of the dismissal date having been granted by this court previously. The court will take notice that appearing for the Department of Family and Protective Services is Ms. Kim Neighbors. Attorney ad litem for the mother, Ms. Cassandra Castro, who is present, is Ms. Gables, who is also here on this session. Ms. Leanne Shank was excused by the court. She did have medical matters. She has been appointed to represent the unknown father, however, has also filed an ad litem report that has been filed with this court prior to this proceeding. Also, we have Ms. Lori Ganoza, who is the appointed attorney ad litem for the child, Jeremiah Alexander Castro. And we have Ms. Karen Soto Lopez, who is here on behalf of the Department of Family and Protective Services. So the court will also take notice that on June 8th, 2018, this court appointed Ms. Leanne Shank as a diligent search attorney for the unknown father. That there was service of citation upon Ms. Cassandra Castro with a return date of June 1st, 2018. The court will also take notice that in compliance with the Texas Family Code, there has been a paternity registry search executed regarding Jeremiah Alexander Castro, and it was executed May 31st, 2018, showing that there is no notice of intent to claim paternity regarding this child. All right, the court will also find that this is the court of continuing and exclusive jurisdiction as required by Texas Family Code Chapter 155, and that all parties entitled to notice, including any 4D agencies, have been notified. All right, all parties present, are all parties ready to proceed?
Yes, Your Honor.
Judge, it's my understanding that we're here today on Ms. Ganoza's, I think, petition to terminate. Is that correct?
It was listed in my docket as final trial. I'm not sure what the active pleading is.
The notice we got from Stephanie says that it is a termination setting. The department is not asking to terminate.
Okay.
Only Ms. Ganoza is. My, go ahead. Oh, wait, my only concern is that we did not receive 45 days notice of this hearing. I don't believe I ever received a file marked copy of the petition. I got one that wasn't file marked, but so I don't know when it was filed. We got notice of the setting, this setting on April 16th. I want to say the petition was filed maybe March 24th, somewhere in there, but we did not get 45 days notice for this hearing.
Okay. So Ms. Abels, just so I can clarify on what your concern, your objections are, it seems to me that you're objecting that you didn't receive sufficient notice of this trial,
Right.
correct?
Yes, sir.
You're objecting to not having a file marked copy of the petition?
Right?
Okay. Any other objections?
Not at this time.
All right. So as far as not receiving a file marked copy, you did receive a copy of the petition. Is that correct? Just
I
not a
think
file
I
marked?
did. I believe I did before it was filed.
Judge, I believe he was handed one in person.
Ms. Espinoza, we have to be extra ordered with Zoom. So I just want to make sure I understand with Ms. Abels what she's objecting to.
Yes, Your Honor.
I'll give you a chance.
I don't remember receiving one that was hand delivered or anything.
Okay, so you're not certain that you received a copy of the live proceedings today?
I don't believe I did. No, sir.
Ms. Espinoza, what is the file date of this petition?
I'm looking for it now, Judge. But what I also filed today that was set on the docket today is my motion to modify the temporary orders.
So Ms. Espinoza, my question was, when was the file mark of the?
I'm looking for it, Judge.
I just want to handle one thing. Is it the March 12th, 2020 original counter petition in SAPSR?
I believe so, Judge. Yes. And I think,
Well, yes, it is, or yes, you believe so?
I'm trying to pull it up now, Judge. Yes, Your Honor.
Okay, good. All right. All right, so my question is, I know there's a certificate of service with this counter petition. Can you verify how or when you had served this to the other parties? I guess that's the first question. Ms. Neighbors, do you have a copy of this?
I do, Judge, but I had to pull it from Jim's.
Okay.
I know that Miss Abels asked me for one previously, and I sent her one. So that's why I'm trying to find the email.
Okay. And while you're looking for that email, could you also find when you sent notice to the parties of this trial date?
Sure. Oh, I'm using the wrong. Keyboard.
Just so we can we go off the record now until you find it, Ms. Espinoza? Is that
Sure, thank
okay?
you.
All right.
Judge,
All right, Ms. Canoza, are you
Yeah.
ready? Okay, hold on a second. So we're back on the record. All right, Ms. Canoza.
so an email went out with I filed the counter petition via mail. So an email went out on March the 9th, 2020, with the letter to the clerk and a counter petition. An additional email went out and all parties were served. So Ms. Abels was served, Ms. Neighbors was served, Ms. Schenk was served
What date did that email go out?
on March the 9th, the date that I filed it via mail.
Okay.
Okay, and then on March the 24th, I sent another letter to the clerk and a letter to the coordinator. And then it says, and I copied Kimberly Neighbors, Key Abels, and Lee Schenk. And it says, Stephanie, please see attached letter confirming that attorney ad litem's counter petition will be heard at the final trial set for March 31st at 9:30 a.m. At that time. So they received the original notice of the trial. So when the court granted my continuance, then this petition for termination would be heard. We just moved what was ever set. So this letter went out on the 24th for the 31st, which is the original trial date that we had set, the court had set. Then the court granted a motion for continuance and reset it for today's hearing.
So it was, what date did you request the trial date?
I requested the trial date on March the 24th, but it was 7 days before trial.
So you requested on March 24th to be heard on March 31st.
Correct, Your Honor.
And then it was continued until today, which is April 27th. That's correct?
Correct, Your Honor. And there was no objection made by Ms. Abels at that time that there would be 45 days necessary to hear the counter petition. In addition, when you counter petition, when you're filing the counter petition, you only need to give 7 days notice.
Not for a final trial.
Final trial? What part of the code are you looking? I may be wrong on this one, Ms. Canoza. So which part of the code requires only 7 days notice for final trial? I'm open if I'm wrong.
I'd have to pull the rules of civil procedure, Judge. I'm just saying the 24th, and I guess we have 31 days. The court said it. If she wanted to make an objection to the 45 days, then she should have when we were scheduling today's hearing.
Ms.
The
Canoza,
court
that's,
doesn't need to give 45 days notice when it resets.
Ms. Canoza, that's not correct. The 45 days notice is waivable. It's not, it can never be automatically waived. So if we proceeded with trial on the merits on something evidentiary, then yes, that would be waivable. But by default, the notice cannot be waived just by not objecting to it.
What day did you email us the file marked copy of the counter petition?
I don't have to email you a file marked copy. The court.
Hold on, please. Let's go back and let's just pause. Ms. Canoza, I'm still looking for the requirement that a counter petition only needs 7 days.
I'm looking, Judge, too.
So Ms. Gonzalez, I'm at TRCP 245.
Yes, Your Honor.
Ms. Neighbors, do you have, while Ms. Canoza is looking for that, do you have your response to the objection?
I mean, Judge, I tend to agree. We did not receive 45 days notice of the termination trial. The department's plan has been since the monitored return was granted in November of 2019 in a very contested hearing, as I understand it. When that monitored return was granted, the department set out its notice that we would be filing a motion, or we would have a trial on a motion to modify the managing conservatorship. That has been the department's final plan. On the 24th is the first notice I received of a termination trial, and I tend to agree that Rule 245 prohibits the trial by surprise. There's a reason why we have the 45-day notice rule. I understand that the dismissal deadline is approaching, but that doesn't excuse the right of each party to be able to prepare and not be surprised by pleadings for termination that are filed so late. If it were the department changing their plan from a motion to modify to a termination, I would expect the same rules to apply to us, and we follow the same rules.
I just want to make sure you can get your record too. I realized I forgot to ask. But Ms. Gonzalez,
I'm looking at TRCP 63, Judge, where it says responsive pleadings. So long as it doesn't operate as a surprise. Within 7 days of the date of trial or thereafter.
wouldn't you agree though, that means there would actually have to be a trial date though?
Right, we had a trial date. We had March 31st.
With a 45-day notice requirement. Any trial date requires 45 days notice.
But under 63, it's a responsive pleading.
Right, so that is, 63 is when there's a responsive pleading within 7 days of a previously set trial date. Right, but that doesn't change the fact that the parties, the concern that I have is the right for a party to be prepared for trial is a constitutional right under the 5th and 6th Amendments. And that is what our legislature has deemed as appropriate to be prepared for trial to get effective assistance of counsel. And so that's my concern because it's a fundamental right. Okay, any other arguments, Ms. Espinoza?
No, I do believe the TRCP 63 spells out that I could do it within 7 days of trial. I did it within 7 days of trial. I do understand the court's concern for unfair surprise, but this case, this motion has been on file for more than 30 days now. The parties had notice of it. The reason it was filed is because of recent activities by the mother. And so there's no real surprise here. I did take other motions. And for the record, I have a motion to modify the temporary orders set at this time as well. So,
Judge, I'm sorry.
and with
The
that,
notice,
Well, hold on, just one person at a time.
yeah,
Ms.
I'm
Abel?
sorry. The notice we got about her motion to modify, we got it last Friday night at 9:30.
that's not true because I gave it to you on Thursday. It just
Okay.
was signed by the judge. You are on notice. And again, that motion to modify was previously set for the March 31st.
Okay.
So
a couple of things. Thursday's still not timely. The other thing is there have been no new pleadings and we had this hearing on her motion previously with Judge Terry, who said that her pleadings and her affidavit were not sufficient.
That
And-
was an emergency. And so now,
What, Ms. Espinoza, Ms. Abels? I just want to make sure you understand, this is not a discussion between you two. It's
I
a
know.
discussion to me, right?
Right.
So we need to stop that, especially with Zoom. It makes it very difficult.
Right.
So we are set today on the final trial on the counter petition for the SAPSR on the termination, right? We're not here on the, I don't have on my docket for the motion to modify, okay, or any temporary orders here. So since we're here on the final orders for termination, Ms. Ganoza, I'm going to disagree with you. 63 is for what I interpret as is when there is a final trial set and there has to be pleadings filed. That does not create undue surprise for the parties, that you can't just dump new pleadings and, so to speak, move the target or move the goalposts after the kick. The problem is 245 creates a fundamental constitutional right, according to, I mean, with case law, with the Supreme Court of Texas, and every party is entitled as a matter of law to the 45 days notice. That is waivable, and it is deemed waived if a party does not raise the objection. But once the objection is raised, I do not believe the court has any discretion on this. And according to, I'm looking at Custom Crete versus K-Bar Services, 82 Southwest 3rd, 655, the 2002 case. But it indicates to me that that there is no discretion with the court on the 45 days. So I feel like I'm compelled to go ahead and grant this this objection. Now, that being said, can we get Stephanie and schedule a court date so we do have a final trial date? I mean, I don't mind giving the trial, but I believe my hands are tied on this one.
Judge, if I may,
Yes.
our drop dead dismissal date is tomorrow.
Judge, if I may respond, the Supreme Court has on emergency order number 3 said that this particular dismissal date can be set out by the court. And so you're not bound by tomorrow's dismissal date. It has suspended those because of the coronavirus.
If I may respond to that, Judge?
Yes, Ms. Neighbors.
My response to that is that those extension deadlines for hearings that are unable to be held, and obviously we are holding a hearing right now. It is not an issue of not being able to hear the case that is preventing it being heard. It's an issue of notice. That's completely apart and separate from the COVID-19 restrictions.
I think there's multiple issues going on with the extension with the Supreme Court order. I'm not going to give my advisory opinion right now, but I think there are concerns by multiple people from multiple angles on the orders. I don't think they really envisioned CPS cases when they came up with that, because it's such a small part of the law as a whole in the state of Texas. Obviously not to the children of the parties, but to the appellate courts. So, Ms. Ganoza, I don't think I have discretion in this. I mean, there's a 45-day notice requirement by law, statutory, and I don't think that notice requirement is suspended. And I don't know if the courts have the ability to temporarily suspend a procedural rule like that either. I think that would be up to the governor.
If you could give me just a second, because I know that I filed a, if I could give me just a second for a response.
Sure.
Okay, I've got it, Judge. For the record, that Texas Supreme Court order says that specifically to the deadlines in section 263.401, which may or must be modified or suspended.
Ms. Canosa, you have to slow down. The court reporter is still trying to take this. So if you can start over, please.
I will. According to the Texas Supreme Court order rendered on March 19, 2020, that order to suspend deadlines applies to all proceedings of the Texas Family Code, specifically to the deadlines of section 263.401, which may or must be modified or suspended, is clearly
Ms.
stated
Canosa, you need to slow down, please.
to avoid the risk of disaster and still protect the interest of all involved in these difficult circumstances. So, and going back to that, the previous order by the court was, even though we can do this by video conferencing, the court is conscious of the fact that at times like this, I've already informed the court, I had 2 witnesses. One is very crucial, and that was Emily Robinson, which is a nurse practitioner who would have testified about.
Judge, I'm going to object because this is not an evidentiary hearing. She's talking about whether or not to extend the hearing or the deadline, but we should not be hearing evidence.
Okay. There's no witnesses. There's no exhibits being entered, Ms. Abels. Ms. Canosa, which emergency order are you citing?
The first, well, the one I quoted to you first was the third, but it referenced the first one. That you can modify or suspend any and all deadlines.
But it says may.
Hold on, Ms. Abels. I want to look. So this is the order dated March 13, 2020?
Yes.
Yes?
Yes, Your Honor. That's the one. It was dated March 13.
Okay, which number?
It was A. Well, it begins all courts in Texas may in any case.
Which number? Which number and letter?
I didn't include the note. Hold on. I'd have to look it up, Judge. Oh, I might have it. Oh, number 2.
Number 2, which letter?
A.
A. So subject only to constitutional limitations, all courts in Texas may, in any case, civil or criminal, and must, to avoid risk to court staff, parties, attorneys, jurors, and the public, without a participant's consent, A, modify or suspend any and all deadlines and procedures, whether prescribed by statute, rule, or order for a stated period ending no later than 30 days after the governor's state of disaster has been lifted. But Ms. Canosa, this is subject to constitutional limitations. The case law shows that the right to notice for trial is a constitutional protected right. So, all right, so now I'm looking at the emergency order number 3, which refers to the paragraph 2A that I just cited. It says it applies to all proceedings under Title 5 of the Family Code, specifically the deadlines in 263.401. That is the 1-year dismissal date. All right, so we're and the extension of the dismissal date. All right,
But it's-
so, and then the Supreme Court order says which may or must be modified or suspended to avoid the risk of disaster and still protect the interests of all involved in these difficult circumstances. Well, interesting question. So the way I'm seeing this, Ms. Ganoza, is that according to this order, you're suggesting that the dismissal date doesn't apply. I don't see how the 45 days notice doesn't apply.
I understand.
I mean, because it specifically says subject to constitutional restrictions, and the current case law says that it's a constitutional right to have the 45 days notice to be adequately prepared for trial.
My additional response to that, Judge, would be just that I would ask the court to take leave that it was filed less than 45 days notice because the events of the mother. Otherwise, I would have filed it sooner. We had recent events. The department did not inform the ad litem of the outcries. So until I received the outcry and assessed the situation and tried to resolve it without filing the counter petition, then I filed the counter petition. So
I understand. And I sense frustration in your eyes, Ms. Ganoza, and I totally get that. The problem is I have my limitations and I'm bound. And
I understand, Your Honor.
I don't think I have discretion with this one. From what it appears right now, I don't think you had any discretion either. It seemed like you acted as quick as you could, but sometimes in the practice of law, you run out of runway, if that makes sense.
It does.
Ms. Neighbors has been in the exact same situation before, where you just need a little bit more runway to get the plane off the ground and runs out. If you want to set this again, I certainly don't mind, and we can set this. We don't need to do this on Zoom. All three of you, I've worked with y'all over the years so much. If you want to call Stephanie and schedule this one within the 45 days, I anticipate there'll be a lot more clarification coming up. Right now, we're still in the state of disaster under the governor here in Texas. So we don't know. I guess we don't know when the ending is on all this. So, but I have no problem resetting this. I do feel like it's a requirement to give the 45 days notice, though. So I'm gonna grant the objection presented by Ms. Abels. Okay. Ms. Abels and Ms. Neighbors, are y'all available either group email or group phone call with Stephanie to try and work something out, or do you want me to bring her into the courtroom so she can get on Zoom?
Whatever's easiest for her.
For Stephanie, email would be the easiest if it's just one chain.
Okay.
Just don't forget to reply all. That kills her. Okay.
No.
Okay, so at this point, I think for housekeeping purposes, I granted Ms. Abel's objection. I think this hearing will conclude. So Ms. Ganoza, if you can let your witnesses know they're released from the rule, and then if we have to reconvene for new trial, I think the rule they should be sworn in again for that matter, because officially the trial can't start today.
So Judge, I did file a motion to extend the dismissal deadline previously. So is the court granting that?
Haven't we? So my understanding tomorrow was a drop dead dismissal date. Is that correct?
That's correct.
Yes, Judge.
No, so you're talking under the Rule 3 that I have the authority to extend the dismissal date even past the statutory required 1 year and then the 6-month extension?
Yes, Your Honor.
May I respond, Your Honor?
Yes, Ms. Neighbors.
So my answer to that is just that those emergency deadlines are intended when there is no way to call a case to trial. Obviously, we're capable of calling this case to trial. The reason that Ms. Ganoza is asking for an extension is not because of the disaster declaration necessarily, it's because she can't meet her 45-day notice. So that, I do not believe, is a ground under which the COVID-19 disaster declaration can extend a deadline, because our final trial was set for today, and the final trial that was set for today is the motion to modify managing conservatorship from the department to Ms. Abel's client. That was what our final trial was intended to be. And I think that the COVID-19 disaster declaration should not be substituted as a way to get around the 45-day notice rule.
So, Ms. Ganoza, where's the motion for extension of dismissal date?
I filed it previous to the 31st. It was filed on the 24th.
Of March?
Yes, Your Honor.
And if I may, Judge, I mean, it's giving someone a second bite at the apple. If the department was seeking an extension for reasons, yes,
Neighbors?
yes, sir.
I'm still looking for the March 24th. There's a bunch of things filed that week, so I'm having trouble finding March 24th. I just want to look at the pleading before we go forward. Ms. Ganoza, I do not have a March 24th file mark of a motion for extension of dismissal date. Is it?
It might have been filed by mail, Judge, so they may not have gotten it to the 27th.
Okay, did you get a file marked return copy?
Let me check in my folder. I picked some things up.
Oh, here we are. It's file marked March 25th. All right, so, all right, Ms. Neighbors, I had interrupted you. What were you saying?
Judge, I was simply saying that it's a second bite at the apple that's not a result of the COVID-19. It's essentially just that, you know, if the department were needing an extension because, for example, a client, we thought maybe a client may be able to get some services, but because of the disaster declaration, they're not able to get them. So we need an extension so they can finish their services. I would understand that being a valid ground to grant a COVID-19 extension for a case of a drop dead dismissal date, but that's not the case here. It's not a question of whether or not COVID-19 has prevented someone from meeting a deadline or meeting a statutory or constitutional notice requirement. That's simply not the reason why an extension is being sought here. In fact, I don't believe it has much to do with COVID-19 at all.
So what is the base pleading on all this, base petition?
The department filed their initial petition for termination back when the removal occurred, and this was, I believe, in 2018. It was filed on May 24th. In November, there was this is before my time with the department, but in November, there was a contested hearing for a monitored return. The monitored return is what extended our deadline out 180 days. The monitored return was sought by the department and opposed by the ad litem. And there was extensive evidence heard at that time, and the monitored return was evidently granted. So that's why we're on the drop dead dismissal date, because we already have our 180-day extension under the monitored return statute, which is a 403 statute.
Okay, now I understand. All right, so Ms. Ganoza,
And in that case, even, sorry, Judge. In that case, the disaster declaration applies to 263.401, not 263.403.
It says the entire family code. It says specifically 401.
well, 403 is, yeah, we're not extending, nobody's filed anything to extend the monitor return. It's after the monitor return expires. Procedurally, I mean, I don't agree with it, but procedurally, you can get the extension of dismissal date after the monitored return. So, okay. So let me go to the issue at hand. So right now, Ms. Ganoza, it's your motion to extend the dismissal date.
Yes, Your Honor. And in that motion, I did say that witnesses might have trouble attending. And as I indicated, there's a nurse practitioner from Cooks that I believe is probably the reason she's refusing the subpoena, but she's been served as far as I know.
Hey, Judge, if I may, when was that motion filed?
On March 25th, he said.
Okay. I can't find it. Wait. Oh, I found it. Sorry. Oh, no, I found the ad litem's motions for witnesses to appear by telephone. Here's it.
So Ms. Ganoza, then my question is on your motion for extension of dismissal date. I'm looking at your reasons. So we're looking at, there has to be one, best interest of child finding. Second, this has to be either an extraordinary circumstance, or the other option is if the parent made a good faith effort to engage in court-ordered drug treatment services, right? So my question for you, Ms. Ganoza, is, are you confident that you will be able to show all three? Best interest, or two out of the three, I guess, either or on the extraordinary or the good faith effort?
Yes, Judge, because I'm based on.
It was a yes or no question. All right. So at this point, this is what I need to do. It's 10 o'clock. We have to prepare. We only have the equipment here to handle one set of hearings at a time. We do have essential hearings for juvenile detainees in our detention facility that were brought in over the weekend. So I was only going to go till 10 o'clock today. Since we are not proceeding on the trial of merits, Ms. Neighbors and Ms. Abels, will y'all be available at 1 o'clock today so we can have this hearing on the motion for extension of dismissal date?
Yeah, but we didn't get notice of this till Thursday or Friday of the motion to extend hearing.
You only need 3 days notice of a hearing.
Right, but you don't count Saturdays and Sundays.
Yeah, you do.
So you got notice Thursday or Friday? Okay, well, I mean, how about this, Ms. Abels? Why don't we reconvene at 1? If there's objection on that, find me the statute of the case law that counts because they're not weekends, all right? And then that, or Ms. Ganoza, same for you. Yes, and then Ms. Neighbors, are you going to be available at 1 o'clock?
Yes, Judge.
Okay, good. So we'll go ahead and do that. So the court is has granted Ms. Abels' objection to the notice requirement. We will proceed on the extension of dismissal date under 263-401. Is there any other matters that we'll hear at 1 o'clock?
Well, Judge, depending on whether or not the extension, I guess, is granted, we may or may not need to hear the department's motion to modify the managing conservatorship, which was originally set.
Okay.
I mean, in theory, I guess if we let the case dismiss, then it's a default that she'll get managing conservatorship back and the department will be removed. But that is essentially what our motion is.
Okay. So what date was that pleading?
That pleading was, I believe, on the 17th of March. And strangely, the notice for that actually went out in December.
All right. Strange indeed. Okay, so those are the two matters that we'll take up at 1 o'clock. Is that?
Yes,
everyone?
sir.
Yes.
Okay. All right, any other
Yeah.
matters we need to take care of right now?
No, sir.
All right, and then just for procedural purposes or housekeeping, Ms. Neighbors, if your client wishes to be there at 1, they're more than welcome to. I don't see that they're necessary parties, so if they have other things to get to, that's fine as well.
Did you say both of us?
Well, for Ms. Neighbors' client.
Okay, I
Yes,
couldn't, I didn't,
both of you, yeah, I mean, this is, I'm sorry, yes, Ms. Abels, both of you. I mean, this is
okay,
procedural and argument. There may be some evidence, but the burden's on Ms. Ganoza. If you need them as rebuttal, that's fine. But I'm just saying, don't feel like your parties are necessary
okay.
on these extensions.
Okay.
All right. All right.
All right.
Thank you. We'll see you at 1 o'clock. It'll be the same live, same Zoom meeting room.
All right, thank you.
Thank you.
Thank you.
Okay, cool. I don't know where it is.
Yvette, are we doing yours first? Do you know? Oh, you're muted.
We are first on the list, but I don't know if we are going first.
Okay. Well, thanks. I got it finally.
All right. Thank you.
Anything that's not written down that I need to know?
No, sir.
Think a parent is going to be there, or?
She indicated she was. I spoke with her this morning.
That's great.
Board is doing another 10 days.
Yeah.
I'm going to be in a Zoom hearing, so you might as well close my door, please.
Okay. Yeah, I can't hear you when you talk. Your voice carries so well.
Okay, awesome. Okay. Sure, absolutely. So
Sleeping under a table in a roadside bar, a man could wake up.
Don't touch your face, Brian.
I got hand sanitizer. I'm good.
I have a face sanitizer. Are you home or work?
Work.
They kicked us out.
Oh, do they?
Which is sort of okay.
Yeah, they hired a bunch of new staff for the building whose sole job it is to walk around and sanitize everything every couple minutes.
Wow. Where are you?
300 Burnett, just next to the public library downtown.
Mm-hmm. Well, so few people were in our building that they didn't really kick us out. They said, would you leave because we don't have anybody to clean up right now because there's not enough work for them to do it. So we said, fine.
Is Ms. Rojas here? Rojas? Hello, Ms. Rojas. All right, Ms. Rojas and Mr. Newman. So the
Yes, Judge.
child, Rojas, I'm assuming no relation, Maria?
No relation.
Okay.
And
So-
then I do want to say that he's only Spanish speaking, and so are the parents.
Okay, so what I'm gonna do, because the child is under 14, and we're splitting up the original detention hearing with the 10 days today with Judge Porter, I'm gonna go ahead and not do the detention hearing for Mr. Rojas. We'll just pass that on to Judge Porter, and he could do it at the very end because the child's under 14. So, Mr. Newman, did you get that?
I did get that, and if the court is inclined to appoint counsel, I'd request that I not be appointed based upon the representations that Ms. Rojas made.
Sure. Yeah, we can do that. We can find Mary, if we can find Spanish-speaking attorney. And so, okay. So today, Mr. Newman, if just to protect the child's interest, we'll keep you on, but then we'll reappoint counsel this afternoon.
Understood.
And then y'all won't have to make any changes on your end. I'm just gonna, Judge Porter will take over as soon as I do all the original detention hearings.
Okay. Thank you.
Thank you. All right, I'm having a problem with the YouTube live stream, so I need to make sure that's going. Okay. Let's go ahead and get started. It's 10:34. All right, so this is the detention hearing docket for the 323rd District Court. We'll go and start. Mr. Alvarado.
Yeah, yes, sir.
Okay, I'm Judge Kim. So this is a detention hearing. The law says when a child is brought to our detention facility, you have to see a judge within 2 business days, and I have to make a decision whether to keep you in custody or to release you. If I keep you in custody, as I did last time, you have to see a judge every 10 business days to make the decision, again, to keep you in custody, or to release you into the community. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you do have a right to remain silent. However, if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. All right, so, Mr. Alvarado, we were here. You have, let's see, juvenile issues going back to when you're 14 years old, some thefts, stolen cars, evading arrest with a motor vehicle, burglary of a habitation, which you're on probation for, and possession of weed. And then now on April 9th, Fort Worth PD brought you in on an arrest warrant for murder. Let's see. Police were dispatched to a shooting call. Found victim unresponsive, died at the scene with a gunshot wound to the chest. Shooter left the scene with, I guess, a witness giving a description of the suspect vehicle. So the warrant said on the day of the murder, 4 Hispanic males were seen driving by the home where the victim was staying. There was a verbal fight. 4 Hispanic males. 2 of the Hispanic males were observed hanging on the running board of the truck they were in. More words were exchanged between the victim and 4 Hispanic males. Before the victim could be brought to the house with his friend, a pop was heard. The victim said ouch, then collapsed in the kitchen. All right, Ms. Castillo,
Yes, Your Honor.
what puts Mr. Alvarado as one of the Hispanic males? Like, I get there's 4 Hispanic males. How do we know Mr. Alvarado is one of them?
Yes, Your Honor, according, I still have the preliminary police report. I haven't seen the full report, or rather haven't received it. But in that report, it indicated that the police had obtained the security cameras from the friend's house where the victim was staying and a subsequent neighbor. And in addition, the 3 juveniles, 3 companions that were with him identified Victor as the shooter.
Okay, so the other Hispanic males identified him as a shooter. All right, and then there was a warrant though by Fort Worth PD, correct?
There was a warrant, yes, and that's what they brought him in.
All right, Mr. Alvarado, even though I'm not certain, like based on what's given to me, personally here today that you were the shooter, there was a judge in Fort Worth that signed a warrant, so he found that there's probable cause. Generally, I'm going to trust another judge on something like that. So I'm going to find there's probable cause. This is a murder case, you know, kids with guns and somebody actually died. This is something that I take the most serious. All right, this is some of the greatest fears in our community. I'm not saying that you did it. What I'm saying is there's just probable cause. Somebody can put into words, if that is true, that you committed this offense. This is not your trial today. This is simply about if there's probable cause, if it seems like there's enough to indicate that you did it, then I have to decide whether to release you or keep you in custody. So I'm also looking now, your behavior level is 1 outstanding, and I'm really glad. It looks like you hit 1 outstanding as soon as you got here.
Yes,
because you came in on April 9th and April 12th, and so you're doing phenomenal back there. This only looks good for you, but I hope you understand my position that is, like, again, I'm not saying that you did it. I'm saying if you did, then obviously I have to be very, very concerned about releasing the public. So I'm keeping you in detention now. Is that paper there a certificate for your 1-0?
Yes, Your Honor.
Good. Man, I am grateful that you have that. I'm proud of you. Deep down inside, I hope you didn't do it, right? I hope this stuff never happens, but you understand that I have to assume that you did. And if that's the case, assuming that you did, it's deciding whether to keep you in custody or release you. Okay, so I'm detaining you for now. Hopefully do something, we move forward with your attorney and get you your trial as soon as possible. But keep that behavior level up, okay?
Yes, sir.
All right.
Your Honor,
thank-
may I ask 2 quick questions?
Yes, sir.
Is there an assistant district attorney on this Zoom hearing somewhere?
I think I saw Janet Farmer's name. Oh, Ms. Farmer's there.
Yes.
Hi, I'm Edwin Youngblood, and Kevin Bodenberg has this case.
Yes.
On TechShare, not one single thing is open. Could you at least open the warrant and any statement that my client might make? Hopefully the whole file, but at least that.
I'll go ahead and let him know that you need that open.
I appreciate it. Thank you. Second question, Your Honor, there's some question about who the parent who has custody really is. It seems like from the most recent thing that Yvette sent me that it's mom, but I wondered if you could make inquiry about that.
Yeah, so Mom, are you here?
Yes.
Okay, what is your name?
Petra Zambrano.
Okay, so are you Mr. Alvaro's mother?
Yes.
Okay, so, and where is Dad? Is he in the picture?
Dad did have custody of him during this time, and about 2 weeks before my son was arrested, his dad was arrested. So his dad's incarcerated. So now he's back. Well, back with me.
Okay.
Back with me now.
What county do you live in?
Tarrant County. Here in
Tarrant
Fort
County,
Worth.
okay.
Yes.
Edwin, is that enough for you?
Yes, if she could make sure to let Yvette know how to reach her, I'll get that information from Yvette and not keep you.
Did you get that, Mom? Or Yvette, did you get that?
Yes, Your Honor, I did.
And Mom, I just, because of the seriousness of this offense, I just want to ask, your son's a United States citizen, is that correct?
Yes.
Yeah, I thought so. Okay, great. Thank you very much. Thank you, Mr. Alvarado. All right, next we have Caleb Davis. You're the parent. Great. All right, Mr. Davis, I'm Judge Kim. This is a detention hearing. Let me explain what's going on. The law says when a child is brought to our detention facility, you have to see a judge within the first 2 business days. And I have to make the decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 days to make the same decision. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. This is not about whether you did it or didn't do it. This is about whether I should keep you or release you, okay? And finally, you have the right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, so let me go over your history first. You're 16 and a half, almost. You've had no priors with this department, your first time with Kimbo. All right, so Arlington PD said, let's see, on the 25th, so I guess a Saturday, about 4 o'clock in the morning, they were dispatched to Red Leaf Drive. Somebody said he heard gunshots and saw 2 black males and 2 other unknown people walk from in between the apartment building next to his. Then one of the black males looked at him, asked him if he had a problem, to which he didn't say anything. He said the suspect then reached into his waistband with his right hand, pulled out a gun, pointed at him, and told him, go back inside. While there, the police got into a foot pursuit with the suspects. Officers gave verbal commands to stop. However, they ignored the commands. See, Devin Robertson was found injured and walking on the side of the road. Devin said he tossed a firearm somewhere. While searching for the gun, they noticed Caleb hiding in the bush and called him out at gunpoint. Then they found the gun. All right, Caleb, I need to let you know up front that it really, my thing is kids with guns. That really, really bothers me. It's a real big issue for me, okay? All right, Dad, is that you? Mom and Dad?
Yes.
Okay, is it bio mom and dad, or is it stepmom, stepdad, or?
Stepmom, bio dad.
Stepmom, bio dad, fantastic. All right, so my first question is, what's Caleb doing out at 4 o'clock in the morning?
That was my question. I was sleeping and Mom was at work. And like I said, by the time we received the phone call, that's when we went and I checked his room and noticed the window was open. He was gone.
Okay, who's Devin Robertson?
Have
I
no
don't know who
idea.
it is.
No. All right, so so he's never been here at juvenile before, right? He's had no priors.
No.
Has he run away before?
No, sir.
How did he do in school back when they were doing school last semester?
He was doing a lot better. He was in the what's that program?
Well, he has a IEP. He's in the 504 program, so he had some additional support teachers because he has trouble staying on task with completing all the work. So he
What is
did
he
have
diagnosed with? What is he diagnosed with?
ADHD.
Is he on medication for that?
No, no, sir.
When's the last time he saw a doctor?
For the ADHD.
Yes.
What was it?
He was in elementary. They end up, his pediatrician at that time took him off because previously when Caleb was younger, he had problems with seizures. And so that the medication made him super emotional, and it had increased his heart rate. So the doctor felt the need to take him off.
That was elementary school?
Yes, sir.
Okay. So you understand the diagnosis doesn't go away, right? But one thing we have to understand about Caleb is as he's growing, his brain is literally changing. I mean, he's growing into a young man. And so they really recommend children with seeing mental health doctors. You're supposed to see them about every 6 weeks, okay? It sounds like it's been over 6 years since the last time you saw a mental health doctor, especially if he's in a 504 program, the resources are available with MHMR. I highly suggest that when you have the chance, you take Caleb back to the doctor, okay? So that's, I mean, that should be, we need to do that because if he needs medication, he needs medication, all right? That's the first thing. Let's deal with Caleb now. I need to figure out what to do. So you don't know who he's hanging out with. You don't know what time he's out, why he's out. Is he respectful at home?
Yes, sir.
Like I said, this is the first time we ever dealt with this. The kids that he hang out with, I like I said, the Devin kid I never heard of.
But any other of his friends we are familiar
Yeah,
with.
they stayed at the house. They stayed the night at the house. But like I said, the Devin kid, I don't know where he come from.
Have no idea.
All right, so Caleb, if I let you out, right, there's going to be a rule that every person you hang out with, they have to come in and they have to shake hands with your dad. Or it's coronavirus, maybe an elbow bump. They have to meet your mom and dad, though. You understand that? There's no more of this, I have no idea who they are. Like, are you good with that? And if your parents say, I don't like them, they're bad news, then what do you do?
Let him go.
What?
Stop talking to him. Let him go.
Yeah, you just, if your parents don't approve of them, then you just, you ditch them, right? I have a feeling that, these people you're hanging out with on Saturday morning, they're people that your parents would not have approved of. Well, I can tell you that because they wouldn't have approved of you being out at 4 o'clock in the morning, right? So, okay, so what I'm going to do is I'm going to go ahead and release you on electronic monitor. Okay, use that as your friend. Okay, that means if somebody accuses you of being outside the house at 4 o'clock in the morning, you can say, Judge, look up my report. It'll tell you exactly how it was. It'll show you being in your home. Okay. So we're going to do electronic monitor, see where you are, make sure you're all right, and make sure you are where you're supposed to be. I'm also setting the rule that your parents meet everyone that you're hanging out with. All right. That's guy friends, lady friends as well. Right. They're meeting everyone. You're not spending any time with anybody that your parents aren't okay with. Okay. Mom, Dad, are you both working during this coronavirus issue?
Yes, sir.
Okay, you're both essential people. So are your work hours the same? Do they overlap or are they opposite?
I work at nighttime.
I pretty much work during the day.
All right. So if you can, go ahead and work with Miss Aguirre. We do offer timeouts and places and errands for your son to run, but at this point, he should be at home.
Right.
Absolutely.
Okay, I think we're on the same page. Mom, Dad, do you have any questions for me?
No, pretty much everything's been covered. I
Right.
don't have any questions.
All right, so then here's my question. I can take this one step further. Mom, Dad, does your son smoke weed?
No, not that we know of, no.
Okay, so this is what's interesting.
Okay.
Mr. Davis, I'm about to ask you a question and don't answer my question yet. All right, let me tell you how this works. The question I'm going to ask you that you don't answer is, if I give you a drug test, are you going to be positive or are you going to be testing positive for anything you shouldn't be? All right. Now, before you answer, this is the way it works. You can tell me no. I mean, you're going to be clean. We give you a test, you're clean, and you go home today on the electronic monitor with your folks. Okay. The other way it can work is you tell me that you're going to be dirty. We'll find out what you're dirty for. We'll give you a drug test, and then I'll figure out some kind of consequence. Now, if you tell me that you're clean and we test you and you're dirty, then I'm actually going to make you stay here until you get to level 1.0 before I release you to your parents. Okay? So those are your three options. I just want to know, if I give you a drug test, are you going to be clean or dirty?
Clean.
What are you going to be dirty for?
I'll be clean.
You'll be clean. Okay, good. All right, so we'll go ahead and do that. So we'll give Ms. Aguirre, if we can just give him a drug screen. We don't need to send in lab, just a screen is good enough. And as long as he's clean, we can go ahead and release him to his parents on electronic monitor right now. Okay?
And then we have to go back to.
All right, thank you.
Your Honor, are you going to keep me on the case, or was I appointed just for this hearing?
You were appointed for this case.
Okay. Same question of the Assistant District Attorney as before. Could you review the file and open what you can for me, please?
Ms. Farmer?
Yes, I will make sure that that gets opened.
Thank you.
And Judge Kim, I'm sorry.
Yes.
When is the next time he'll have to come back to court?
We will let you know the court setting, but it will be after this coronavirus kind of stay-at-home shelter-in-place is lifted.
Okay.
So we're probably looking realistically June.
Okay.
Okay, but you may not have to. It's his first offense. If it turns out that Caleb's a good kid, where this was just one bad decision and he didn't do anything really bad, like he's not the gun guy, things like that, then you may not even come to court. This may be one of those, hey, you know, show us that he can act straight, he's respectful to mom and dad. You hear that, Caleb? Respectful to mom and dad. All right, he's following your rules, doing what he's supposed to do. Then we just may dismiss the case outright. Okay?
Yes, sir.
All right, I appreciate it.
All right.
Thank you.
Very much. All right, so we have Alexis Debery.
Your Honor.
Or, yeah, I think I did.
Your Honor.
Oh, okay. Yes, sir.
There's one correction on my offense report I'd like to point out before you get started.
Yes, sir.
The bottom sentence under the offense where it talks about the officer returned the phone to the victim. That should read January 23rd, 2018, not 2019.
Okay. Hello, Alexis.
Hello.
This is a detention hearing. So the purpose of this hearing is that when a child's brought to our detention facility, they have to see a judge within 2 days, all right? Now, you're 18, you're not a child anymore, okay? So, but I still have to see you within 2 days, all right? If I keep somebody, they have to see a judge every 10 business days. Because you're currently on probation out of this court, in theory, I can keep you for this matter until we figure out what to do with your case. But I'm very limited because you're now over 18 years old, okay? So technically you're adult by the eyes of the law. However, the law allows us to exert jurisdiction over kids that had a case when they were juvenile all the way up to their 19th birthday, right? So you have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. You have the right to an attorney. Mr. Youngblood or Ms. Tillman has been appointed as your attorney. All right, so yesterday, 4th PD brought you in. You called police for help because you're having thoughts of harming yourself. And when the police got there, you ran. They ran your name, and there was a warrant for you out of this court because you didn't show up in August 22nd of 2018. All right, so this all started from let's see. Somebody was at Walmart shopping, took her stuff to her car. When she was unloading her merchandise, she left her purse in the shopping cart. When she came back, the phone was missing, purse was missing. Police got there, saw surveillance video. They saw an employee move the shopping cart with a purse in it to the cart corral. Then he was seen on the phone. Alexis got the phone, went to women's restroom. When she came out, did not have the purse. And they detained her and found her with an iPhone 8. So,
Judge, if I may interrupt you,
yes.
I'm not the prosecutor on this case, but I did want to let you know that it looks like the prosecutor is dismissing this case and may have dismissed it just this morning. So based on that, we would have no problem with her being released. Doesn't look like there's any other case that we have with her.
So is the case dismissed or not dismissed?
It looks like it was dismissed this morning, Your Honor.
Like filed, or y'all fill the paperwork out?
I think, and I'm double checking right now, but I think the documents were already given to our secretaries to take to the clerks, but I'm making sure on that right now.
Well, Ms. Farmer, it's just a simple question. Like, I mean, I'm trying to simplify it. It's like, has it, well.
Sharon, I might be able to shed some light on this. I contacted Andy this morning and she said that she was going to go ahead and do that.
Right. So here's the question. Has the judge signed is it dismissed yet, or is it in the process of being dismissed?
I am asking her right now, Judge.
All right. All right. So, Ms. Devery. All right. And you're positive for weed, but I mean, whatever. All right. Are you okay?
I'm fine. How about yourself?
No, Ms. Devery. Oh, no. I'm talking about your daughter.
Oh.
Alexis. You there?
Yeah.
Are you okay?
Yes.
You sure? I mean, you called the police for help last night, then you ran off. Like, are you good? Okay.
I'm going to step away quickly just to ask her if a judge has signed that dismissal, Your Honor.
All right. Mom, does she have a case with MHMR?
She did. When we lost our Medicaid, I wasn't able to afford her medication. But as soon as she's released, I will take her to go get the help that she needs.
Alexis, when's the last time you were on medication?
Over a year ago.
Okay. How did it make you feel?
It helps, but I told my psychiatrist that taking all of it at once, because they had me on 4, that it made me hallucinate.
Right. Yeah, hallucination is bad. You can get that adjusted. Hey, here's my advice. All right. A lot of the mental health medication, it's going to make you feel a little bit cloudy, a little bit funny, not right. And that means it's working. Now, if it makes you hallucinate, then you need to find different medication. Okay. And one thing you have to realize is when you get on medication, you're still 18 years old. You're young, right? You're just a kid. I mean, you're an adult, but you're a kid, right? So this is the thing. Your brain is still developing, right? It's still changing. That's just going to happen for a female till you're 25 years old. Okay. So when you get back on medication, give it a chance. If it's not working, go ahead and get the doctor to adjust the medication a little bit, because what might work one week, because your brain is physically changing, it may not work a couple weeks later, and you just have to keep on getting adjusted until you're in your late 20s. And once you're in your late 20s, they should find that right balance. That shouldn't change. You see where I'm going with this? Right, so give it a shot. I mean, but I think you need your medication. But you know what? You got a mom that loves you, right? There's plenty of children that come through here. The parents don't show up. You're a grown woman. And your mom's here for you, all right? That's a huge amount of love. There's a lot of people who care about you. Just, man, work the system, all right? Try and get you some help. I don't want to keep you. You want to stay here? Okay, I don't want you here either. You ready to go? Are you living with your mom?
Yes.
Okay, you ready to go back home? That's a yes?
Yes.
Okay. All right. So I'm going to go ahead and send you home. Mom, you can try and get her help that she needs?
Absolutely.
Okay. All right. So Miss Alexis Devery, it looks like the DA is going to file to dismiss your theft case. All right. So hopefully you and I won't see each other anymore, but you understand, just now that you're 18, you pick up another case, you go downtown court, right? Okay. So I just want to make sure you understand. Just stay out of trouble. Okay.
Okay.
All right. Give the medicine a chance. Give the doctor a chance. Don't be afraid to tell the doctor what's going on. They're here to help you. Okay. All right. Thank you, Ms. Devery.
Thank you. You want to go pick up at the back side?
Carla Navamontanes.
I'll be inside the phone with Mr. Vickerson, and then you'll go around here.
computer, and then she can send your victim, just don't have her in the seat. Just over. Sit down. Yeah.
Sir, what is your name?
Edward.
Edwin. Wait, can you say that? Your name is Edwin?
Edward.
Edward.
He's my kid. It's Zombie Mana Edward.
Okay, that's a 10-day. That's going to be after this is done with Judge Porter. Right now, the next one should be Carla Nava Montanes.
Yes.
Okay. All right. Hey, Edward, you're going to be up on the next round with another judge. All right. I'm going to ask you to step out, and we're going to bring the juvenile for the next detention hearing. Okay. Sorry about that.
They say, not me. Where it is. Highlight it. You'll see her come in. Right?
Judge Kim, who do you need next?
Carla Nava Montanes.
Okay. Yes, sir.
Is that Maria's office? What's that about there? It looks like she's like, what's in the back? What are those tires? What a view. Hello, Carla.
Hi.
Hi, I'm Judge Kim. So this is a detention hearing. I need to make a decision whether to keep you in custody or release you. This is not about whether you did it or not. This is simply about whether I should release you or not. Okay. If I keep you, the law says, now, since you're brought here, you have to see a judge within 2 days. And if I keep you here, you have to see a judge every 10 days to make that same decision. Now, I'll let you know that you have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. Okay? So you're 16 years old. You have, well, let's see, last July, I guess right before your birthday, so you were 15, you were brought here for assault, bodily injury, injury to child, elderly, or disabled. They were all dismissed. So now, on Saturday, the police said about 11:30 in the morning, they were dispatched to group home. They made contact with the caretaker, said Carla went to call her mom, but the caretaker told her she needed to complete her daily activities before she was allowed to call. Caretaker went to the sofa to lay down because she was having stomach pain. She opened her eyes, saw you standing over her with a knife in your hand, which caused her to be afraid. She got up and locked herself in the bedroom and called the police. Then she heard you say you were going to kill yourself, but nobody was actually injured. Now you're level 3 confined since there, so it's just gone down. Are you self-secluding?
No,
No, why are you confined?
I don't know.
Oh, yes, you do. They don't put you there for no reason. Who are you having conflict with?
I had to be restrained.
I'm sorry?
I had to be restrained.
You had to be, oh, why? You gonna fight?
Yeah, I got upset because I wanted my medicine.
Okay, are they not giving you your medicine back there?
They didn't until someone finally came and brought my medicine here to the detention center.
Okay. Are you in the group home because of CPS?
I don't know.
Oh, you don't know why?
My mom knows.
Okay. So are you mom or are you the caretaker?
Mom.
You're a mom. All right. What is she diagnosed with?
There's an array of different things. We're not really sure. One of them is
ADHD, ODD, bipolar schizophrenic, and there's several others I can't recall right off the top of my head.
So she is diagnosed ODD?
Yes.
Hey, Carla, so this is my thing right now, okay? Like, I don't want you here, but I got to make sure other people are safe, right?
Yes,
Like,
sir.
I can't have you threatening other people. I got to make sure you're safe. I can't have you threatening yourself.
Yes, sir.
See where I'm going with this? Like, that's my job, right? My job is to help you because you're not 17 yet, so you're still a child, according to the criminal laws. But my job is to try and help you and make sure that you're not going to hurt yourself, you're not going to hurt other people.
Yes, sir.
But if you're level 3 confined, how do I know you're not going to, like, right?
I'm
Like,
gonna prove it. I'm gonna prove it.
okay, so you think you can get to level 1.0?
Yes.
Okay. Are you confident on that?
Yes.
But you know, a lot of that is just simply just not reacting, right? Like, you don't like the situation. But so what are your coping mechanisms? What do you do to calm yourself, like when things are getting out of control?
I watch TV or I listen to music or I read.
Okay, but you don't have all those options back there, right?
I know.
So what do you do when you don't have a TV or music or books?
I would just sit there and talk to myself.
Okay, does that work?
Yeah.
So you kind of talk yourself out of it, right? You talk yourself down?
Yeah.
Okay. Like, can you do that for me?
Yes, Your Honor.
So here's my thing. Now I understand you have other things going on, but if you're getting your medication, that's going to help. But I need to be confident that if I release you and you go back home to your mom or you go to another group home, that you're not going to pull out knives again, right?
Yes, sir.
Okay. So she's ODD.
And
so
Judge,
Ms. Paxton, yes, who's?
Judge, I've been reading the offense report that's been provided to me. I do not think this meets the standard for probable cause. There's just not a causal connection between her having the knife or making any direct threat. I think it fails to meet the test under 2201 of the Texas Penal Code for the purposes of the assault, which is later incorporated in the ag assault statute. I just don't think there's enough meat on these bones to constitute an offense.
Well, Mr. Newman, as you know, I am always open to your argument. But as far as the elements of the offense, I think a person can reasonably believe when you open your eyes from laying down and somebody standing over you with a knife, that is at the very least recklessly putting somebody in fear. But I always welcome your arguments. I mean that sincerely. But yeah, if it makes you feel better, yeah. Hey, look, Carla, here's the thing, right? I think you got bigger issues going on, right? I mean, I just need to know that people are gonna be safe if I let you go. Right?
I am gonna be safe.
Okay. Well, it's not, you're gonna be safe and other people are gonna be safe too, right?
Yes, sir.
So here's the thing, you're level 3 confined, okay? It takes about 3 days to go up a level from 3 to 2 and about 3 days to get from 2 to 1, okay? I'll tell you what, if you can get to level 2 outstanding, right, I'll let you go. I usually make kids wait till level 1 outstanding, okay? But here's the problem is, for you to get to level 2 outstanding, that means you have to do everything right. Like, you have to find your own coping mechanism. You have to talk yourself down, right? If you can prove to me you can do that, I'm okay with letting you go back to that group home if they'll have you back, okay? You gotta take your meds, you gotta control yourself. But you know what, if you stay at this level 3, you're gonna be here for a while. You know that, right?
Yes, sir.
So who's in control of what's gonna happen?
Me.
Only you, right?
Yes, sir.
Right. So you're gonna make it happen, right?
Yes, sir.
It's not gonna be easy, right? I know it's tough, all right? You got a bunch of things going on, but I'm counting on you to do this, okay? Show me that you can do it, and we'll go out and get another chance for you. Okay?
Your Honor, if I may,
Yes, Ms. Paxton.
I did speak with the owner of the group home, and they're not willing to have her back right now.
I understand. So we'll have to find another alternative. Mom, is she placed in a group home through CPS, or how did she end up there?
I placed her there.
You placed her there. Okay. You may be wanting to look at other alternatives. Start looking now.
I wish I could find some. I've been looking for a while now because she's been having problems at this particular group home for a while. And so I've been looking and talking with our HMR rep, who's supposed to get back with me this week because, you know, I'm kind of like out of options for her, but I've had her in so many different places that, you know, everyone pretty much, most of the facilities locally and further out like Belton and all this, she's been there and she never lasts. She's only stayed probably maybe 3 weeks, which is a long-term program, but she get to acting out and fighting, and I'm really out of option. I don't know what else to do.
Right. Do you feel safe or not safe if she went home with you?
Oh, she can't come home with me because I have other kids in the home that, you know, she's attacked, and I have a smaller one and she's attacked me as well. That's why she's in the group home.
Have you called Child Protective Services?
Yes, they've been in our lives for some time, and I got to a point, I adopted her, and I got to a point that her behavior was so out of control and I couldn't do anything more. So I told them that I would like to put her back in the system.
Right.
And they threatened me, well, if I did, I would possibly go to jail for child abandonment and be forced to pay child support.
Yeah, that's not, well, I mean, child support is a possibility because there's an adoption, but you know, if you call CPS and tell them you want to, it's called a wrapper. Okay, RAPR.
I've been there. We've done that.
And they won't take her?
Nope. I've been so many places trying to get her help as well, opposed to trying to put her someplace else. And CPS tells me, to be in fact, I was speaking to someone from CPS about a week ago, and they told me, well, don't really call us because there's nothing we can really do for you.
Yeah, that's their job.
Yeah.
Keep on calling them. That's what our tax dollars go for, is because what it is, and Carla, I'm not saying this so your mom can just drop you off, right? I'm saying this because CPS has treatment options, they have placements, they have all kinds of options that your mom does not have access to. Okay. So I'm not asking your mom to abandon you or to leave you. What I'm saying is a lot of times CPS can open doors for more help for you that your mom can do by herself. All right. Okay. I just want to make sure you understand that. So Mom, I would keep on calling. I mean, this is their job. If that doesn't work, I would call your elected officials, your state reps, your state senators, because this is what CPS is supposed to do. Okay?
Okay.
All right, Carla. All right, let's get to level 2.
Yes, sir.
Hang in there for me, okay?
Yes, sir.
It's easy to say yes, but it's harder to get it done, but you can get it done, right?
Mm-hmm.
Okay. Get it done for me. Thank you. Shirleycia Parker.
What do I do from this point?
All right, Ms. Parker. Hi, I'm Judge Kim. This is a detention hearing. When a child is brought to our facility, the law says you have to see a judge within 2 business days and have to make a decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 business days to make the same decision. Also want to let you know you have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have the right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, this is not a trial about whether you did it or didn't do it. This is about whether I should keep you or release you. Okay? So at this point, I'm looking at your history. You're 17 in June. It started when you were 13 years old. 13 years old. There was assault, bodily injury, which got dismissed, engaged in organized crime, maybe like a gang fight or something. Let's see. Then you were 14 years old. You had an evading arrest in a vehicle and a theft of property of $2,500 to $30,000, probably a stolen vehicle. You got probation for that, but you had some problems on probation. So, let's see. Ms. Thomas?
Yes,
She's currently on probation for the stolen vehicle and evading, correct?
she is, Your Honor. That probation was extended on June 3rd for a year.
Okay. And then now we have, let's see. And then we brought you in on Saturday and you tested positive for marijuana, amphetamines, and methamphetamines. All right. So, Ms. Parker, are you on any kind of prescription medication?
No, wanting to.
Okay. All right. All right. So, Westworth Village Police brought you in on a warrant that we issued in January for not reporting. Arrest you without incident. You're living with an adult female friend. When in December, the friend notified us saying that you could no longer stay there because you weren't following the rules. And then Ms. Thomas was there when you were asked to leave. Said you're going to live with a family friend, but did not know the address. So we told you once you get to that friend's house, you need to provide the address, and you never called. So we called you on January 7th, you provided a different address. You said you would come in the next day, or the officer would go there the next day. When she went there, nobody answered the door, and you would not pick up your phone. So we should warrant for you. So you were previously on caseload, and you were gone for 9 months, and you were living with a 21-year-old man and his mother.
Supposedly.
All right, Ms. Thomas, how old was she at that time?
She was 16, 15, 16. She was gone for probably 9 months when she was on the pre-probation officer's caseload.
Sure. So she was 15 or 16 years old, living with a 21-year-old man.
Yes. Was involved in everything, Your Honor.
All right, Ms. Parker, here's the deal. I know you're almost 17, but we have a warrant for you for not living where you're supposed to live and not showing up and reporting. The fact that you're positive for the weed, you know, I mean, you're not supposed to, but you know, that's not the deal breaker for me. The deal breaker is the methamphetamine, the street drugs you're using. The deal breaker for me is that you will live with a 21-year-old man when you're 15 or 16 years old, that you're on probation for a felony. You understand what an indeterminate sentence is, Ms. Parker? I'm sorry?
No, sir.
Okay. Indeterminate sentence is a case with juveniles, you commit a felony level offense, all right? You can be committed to TJJD. You know what TJJD is?
Yes, I know what it is.
You know what it is, prison for kids, right? So what it is not a number of years. I can't send you there for 10 years or 20 years. I would send you there and they would provide you the classes and the programs. And if you did everything, if they felt like they were comfortable, that you're rehabilitated, that you're gonna make good decisions, they'll let you go. And then you just get out. It can be one day, it could be all the way up until your 19th birthday, but that depends on you. You are on felony probation, so you can be committed to TJJD. So you have to understand the decisions that you're making could result in you being detained at TJJD all the way up until your 19th birthday, okay? But that's not what I want to do. I really want you to do well. I want you to thrive. I know you got kind of a rough situation. Mom's not stable. You're kind of shuffling around places. You're kind of being forced to grow up a lot faster than you're supposed to, but you just got to grow up faster than you're supposed to, okay? You got to follow the rules. You got to do what you're supposed to do. So at this point, I'm detaining you. We'll revisit this later. A large part of this is you have to understand, I can't just let you out on the street. Your mom's not a stable place. You won't tell us where you're living. Like, I can't put a little 16-year-old girl out. Yes, ma'am.
Can I say something?
Yes.
That I gave my PO in January, I'm currently still staying there.
Okay. Talk to your attorney about that, because that's not what I'm about right now. This is about detaining you, releasing you. But your attorney can definitely help you with that and figure that one out. Now, that being said, and don't say anything in response to this, no matter where you're living, I'm probably not happy you're testing positive for meth.
Can I say
Right.
something on that?
All right, don't say anything about that, but I'm just saying, wherever you're living is probably not a good situation if you're testing positive for meth, whether it's people there that you're in contact with it, or if you're using it yourself, all right? So there's other issues going on here. It's not just about where you're living or the phone calls. There's a whole bunch of other things going on, okay? So get to level 1.0, show me how you're doing, and we'll revisit this in the future, but I gotta feel safe about releasing you. Okay, you're too pretty and you're too bright just for me to throw you out on the street. All right? Okay, thank you.
Thank you.
All right, Devin Robertson. Here's the last one, the 13.
Right in front of there's two chairs right in front of there.
Good morning, Your Honor.
Good morning, Mr. Dotson.
How you doing, sir? I just
I'm
want
doing well.
Good to see you. I just want to add, once I got in the office, I received a phone call from Arlington PD. This young man is going to have another UCW coming on a charge that happened Tuesday the 21st. They still wouldn't have the details.
Okay.
That message.
We can figure that out then. Right now. All right, Devin. So this is a detention hearing. The purpose of this is not about whether you committed a crime or not. It's about finding out if I need to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 business days to make that same decision. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you.
Judge Kim, excuse us. They sent us the wrong youth.
Oh, this is not Devin?
No, sir.
Okay, well, let's get Devin Robertson. I'm amazed how well this works. Like the system, like this is the first mistake in 2 weeks. What's wrong? I guess there were 2 today, but yeah. I mean, this is. In some ways, it's much smoother than in person because outbursts are just gone. Yeah, it's pretty amazing. Hello, are you Mr. Robertson? It's on mute. Okay, are you Mr. Robertson?
Yes, sir.
Okay, good. All right, so I'm Judge Kim. This is a detention hearing. We're not here to have a trial or decide whether you did or didn't do it. We're here simply to decide whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 business days to make the decision whether to keep you or release you. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have the right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. For the purposes of today's hearing, I've appointed Mr. Newman to represent you just to see what's going on, or just to give your time to find an attorney or to ask for an attorney. All right, so Mr. Robertson, you are 15 years old and things started, let's see. All right, so no priors with this department. All right, so on Saturday, Arlington Police said they were dispatched to a 911 call on Red Leaf for a victim saying he heard 4 gunshots from the back of his complex. He saw 2 black males, black females walking in his area. One of them asked if there was a problem, and the victim did not respond, at which point one of the black males reached into a waistband, pulled out a handgun, pointed at the victim, and told him to go back inside. Officers in uniform checked the area behind the victim's building, saw a group of what appeared to be teenagers, gave verbal commands of "show me your hands." The suspects ignored the commands, began to run away. When more officers got there, they saw a suspect injured and walking along the road. He was identified as Devin Robertson. He was placed in custody. While in the back seat, the officer heard Devin with a spontaneous utterance asked that it was me, I'm the one who shot. Devin told the officers that he tossed the firearm over a fence at the back of the complex. When they canvassed it, found another suspect hiding in the bushes. He was called out and identified as Caleb Davis. At this point, both suspects were charged with evading arrest. Devin initially lied about where he threw the gun. However, he gave the true information. Firearm was found, taken into possession by Arlington Police. So now he was charged with UCW. Devin told the officers this all began with a fight he had with his dad. Said he was outside with his girlfriend when he was asked by his mother to wash the dishes. He said this embarrassed him, so he began to talk back, which caused his father to address him physically and verbally. Devin said he was hit several times. Mother was able to separate them. Devin ran outside to grab his gun behind a bush where he keeps it and fires shots above his head of his father to scare him. Devin believed his father was holding a gun, then went to his girlfriend's apartment. During this incident, Devin injured his knee while evading the officers. Medically cleared. Contact CPS and brought over here. All right, so Dad, your mom and dad?
Yes, sir.
All right, so how much of that I just said is accurate? Like, did y'all get in a fight over the dishes?
Yes, sir.
Okay. So, does he pay for the food?
No, sir.
Does he pay for the electricity?
No, sir.
Dishwashing soap?
No, sir.
Clothes on his back, the roof over his head? Any of
No,
that?
sir.
Does he have a job?
No, sir.
Does he help with any of the bills?
I wish.
So his job is to do some chores.
Yes, sir.
And that's a problem.
And do schoolwork.
Do schoolwork. How's he doing the schoolwork? He's not good in the chores. How's he on the schoolwork?
He's the same way with the chores, halfway.
That's not what I want to hear.
Right.
All right, so who is this Caleb Davis? Do you know that name?
I don't.
Well, if it makes you feel any better, his parents don't know your kid either. So they just kind of met on their own, all right?
Okay.
But they seem like they're good folk as well. So who's his girlfriend? How old is she?
15.
Okay, about the same age?
Yes,
Is
sir.
she a good person or is she trouble?
She, as far as I know, she's good. I just know he talked to her and they just be outside, right outside the house.
So you never met her before?
I met her once. Yes, sir.
Mom, have you met her?
Yes, sir.
Okay. You approve of her?
She seems like a pretty decent young lady. Yes, sir.
Okay. You met her parents?
I haven't.
Okay. Well, if your kids are dating, you should probably meet the parents too, right?
I totally agree.
Okay. So that's not my job. I'm not a relationship counselor. I'm here trying to figure out what to do with Devin. So, all right, here's my concern. He has no priors with our department, okay? It seems like, Mom, if you're the kind of person that will step outside and call him out to do the dishes like he's supposed to do, like I like you, like I like your parenting.
Yes, sir.
Normally, I'm very comfortable letting him kill children go. However, here's the deal breaker for me: is there's a gun involved. Okay, right. I take children with guns with utmost seriousness and concern. There are too many children that end up killing people and getting killed, and so I have to be very cautious and comfortable before I release a child when there's a firearm used. Okay. It's actually kind of scary that he stored the firearm outside behind some bushes.
Like, I don't even own a firearm myself.
Which is good news, right? So it actually would make me feel more comfortable if it was your firearm that he happened to take, because now we know where he gets the guns from. Now we have no idea if he can get another one or not get another one. It's just so many unanswered questions at this point. So here's what I see as part of the problem is I see the problem is Devin wants to do his own thing. He's smarter than everyone else. He wants to be a man. And when you want to make grown-up decisions, there's grown-up consequences, right? And Devin, this is part of your consequences. So with a gun involved, even though you're 15 years old, right, I'm going to detain you, all right? I'm going to detain you until I feel comfortable based on your behavior level that you can go home to your parents and show them respect. But I'm going to let you know, if I release you to your parents, you're going to be doing the dishes, not when your mom asks, but you're doing the dishes every day, 3 times a day until coronavirus is over. All right. And we're not talking about doing the dishes so it's halfway done, so your mom has to go back and do them again. They're going to be clean. If they're not clean, you're going to be doing the dishes again until she's happy. You're not going to be breaking dishes. You're not doing any passive aggressive stuff. And you're going to do more chores too, because if you're not helping out with bills, then you need help out at home. This is life, right? We all have responsibilities. And if you're too big of a man to go in and do dishes to help the lady of the household, then you know what? You need an attitude adjustment. I think your parents both agree with this one, okay? So let's wait to your behavior level. I'm not even going to consider letting you out unless you're level 1-0, okay? So if you're floating around 1 acceptable to level 2 and so on, you're going to be here for a while. And I have no problem with that because you've shown me, based on the fact that you're a child with a gun, that you can handle the situation. And I have no problem with that. So here's my concern. He has no priors with our department. Okay. So if you're the kind of person that will step outside and call him out to do the dishes like he's supposed to do, like I like you, like I like your parenting. So let's wait to your behavior level. I'm not even going to consider letting you out unless you're level 1-0, okay? So if you're floating around 1 acceptable to level 2 and so on, you're going to be here for a while. And I have no problem with that because you've shown me, based on the fact that you're a child with a gun, that you can handle the situation. that I have to be extra cautious. But get to level 1.0, then we can have this discussion. Your attorney knows me well. I'm very consistent. Mr. Newman will let me know, hey, Judge, it's about time. And then I'll consider it. And actually, every time he's asked, I've said yes, but he only asks when he knows I'm going to say yes, if that makes sense. All right, so do your part to help him, and then we can go forward here and get you back home. So you can prove to me on the outside that you can be respectful and follow the rules. Get to level 1.0 in our detention facility. That way you have a chance to get to level 1.0 at your parents' house, okay, and keep it there. You understand what I'm saying?
Okay.
All right, Mom, Dad, this is tough. I understand, but I hope you understand children with guns is my thing. That is the thing I'm most cautious about. And honestly, I don't think y'all could have done anything about it. He found the gun in his zone. He had the gun outside the home. If you look back and you think, what could I have done different? I don't know if you could have at this point. So don't blame yourselves over this one. All right. Devin just tried to grow up a little bit too fast this time. All right, Devin, do you have any questions for me?
Yes, sir. You said do what when I get to level 1.0?
Well, so it takes 3 days to shift from the number, level 1 to level 2 to level 3, up or down, okay? So you just came out Saturday, so in theory today, you can actually adjust up to level 1, all right? Now, you could then within level 1, within each level, you have outstanding, acceptable, unacceptable, O, A, and U, all right? And you can float in between the numbers. It takes a major to go down, but it takes consistent behavior to go up. So you're consistently behaving, doing the right thing, then that will reflect in your behavior level, at which point your attorney will know, hey, Judge, even though this kid had a gun and, you know, I think he deserves a chance, this is one to reconsider. So Mom and Dad, I'm assuming that y'all want him home now, right?
Yes, sir.
Okay. So Devin, this is not about your parents. They're not telling me, they're not sending me secret signals. They want you home. This is my decision, because I'm extra cautious when kids have guns. I need children to understand in Tarrant County that you cannot have incidents involving firearms and Judge can be okay with it, because I'm not okay with it.
Yes, sir.
Okay, that's where you cross the line. You understand?
Yes, sir.
Okay, so get your behavior leveled up, give your attorney something to work with, and then he can talk to me about it, okay? All right, thank you, Ms. Robertson.
Love you, Mom.
Love you too.
All right, so at this point, we're going to continue the 10-day detention hearings. I will have other matters to take up with this court. So Judge Porter will be taking over. And if you are watching the live stream, this will resume with Judge Porter.
All right.
All right, Judge Porter, are you there?
I am.
Okay, I'm going to go ahead and make you the official host. Take myself out of this.
There's another phone right there. Yeah, I was gonna email that to you. I'll go get him.
Thank you. Right, if I could have Mr. Edward brought. Are you Mr. Edward? Are you Mr. Edward?
Sir.
Is that a yes or a no?
Yes, sir.
You are Mr. Edward?
Yes, sir.
All right. If I can get you to move your chair closer to the computer. All right. Mr. Edward, my name is Judge Porter. You have the right to have this hearing in front of Judge Kim. You also have the right to have this hearing recorded. If you want either of those things, your attorney, Mr. Youngblood, will let me know. Do you see Mr. Youngblood on the screen?
Yes, sir.
Okay. This is a detention hearing to determine whether you should remain in the back or be released to a parent or guardian. I will let you know that this is being broadcast on YouTube. Anyone who is watching this on YouTube, you are forbidden from recording this hearing in any way, shape, form, or fashion, or rebroadcasting it in any shape, form, or fashion. Violation of the order of this court prohibiting broadcasting or Recording of this hearing is punishable by criminal and/or civil contempt, meaning you could be fined or placed in the Tarrant County Jail. All right. Mr. Edward, according to the police report, a directive to apprehend resulted in you being brought in by the Fort Worth Police Department. So apparently there was a curfew alert. You've been previously released on electronic monitor, but you went out between 1:30 and 5 a.m. Currently pending a UCW from Fort Worth PD. Placed on probation last summer for 2 burglary of habitations and attempted burglary of habitation and possession of marijuana. You completed the DPP program in December of this year, or last year, sorry. The last drug test shows March 10th, positive for marijuana. Has he had a drug test since he's been back in detention this time?
Yes, Your Honor. He was drug tested on April the 9th and he was positive for marijuana.
Oh, again. All right. Does he have a parent or guardian here today?
They are here.
All right. I see somebody's back in the parent courtroom. Are you the mother or grandmother?
Yes.
And which are you? Are you the mother?
Yes.
All right. What's going on? Why is he out between 1 and 4 in the morning?
I don't know.
How did he get out?
May I interrupt, Judge? We've had some discussion before about whether this person is an aunt or some other caregiver and not really the mother. And she may not know because she's not actually caring for him at the time this happened.
Oh, so are you the mother or not?
Mother.
She is the mother, Your Honor.
Okay, do you?
Possibly he was with the aunt at the time. I can't remember.
Okay. Okay. Ms. Blair, how long has he been level 1-0 in the back?
He just got on level 1-0 on April the 24th.
Okay, so 3 days.
Yes.
All right.
Can I say something?
You have the right to remain silent and not say anything at all. Anything you say during this hearing cannot be used against you at a disposition or adjudication hearing, but it might be used against you at another detention hearing. Last time you talked to the Judge Kim, he told you you needed to be on level 1-0 for 14 days, correct?
Yes, sir.
Is that a yes?
Yes, sir.
Okay. Have you been on level 1-0 for 14 days yet?
No, sir, but.
All right. So according to the agreement that you have with Judge Kim, should I release you or detain you?
Detain me.
What was that?
Say detain.
All right. Mr. Youngblood, do you have anything else?
Still a little confused about who the actual caregiver is on this child, who this child actually is supposed to be with. And so I'd like to get that straightened out if possible.
All right.
Ma'am, Was somebody else taking care of your child when this is supposed to have happened?
She don't speak English, so.
Oh, all right. Well, that may be the source of the problem from the previous hearing then, Your Honor. She may have been answering questions without fully understanding what was meant. So I don't want to bog the court down in a translation problem right now, and I'll just rely on Ms. Blair to get me the information.
Your Honor.
Ms. Blair, can you meet with the mother to find out what language she speaks and arrange for an interpreter?
Yes, she speaks Kirundi, and the older sister has been showing up to translate for her. I believe she's not here today, but the lady that's beside her, she's the one translating for her today.
Okay. Do you have contact information, Ms. Blair, for the mother?
Yes.
All right. And Mr. Youngblood, do you need that contact information, or do you have it?
No, sir. If I have it, I don't have it before me right now. I've got two monitors, but I may not be able to see it because it's hidden.
All right. Ms. Blair, will you be able to provide Mr. Youngblood with the mother's contact information, and then also be able to provide him with the name of the sister and hopefully phone number who's been translating? That way Mr. Youngblood will be able to converse with the parent?
Yes, I'll email it to the information today to him.
Will that work, Mr. Youngblood?
Yes, thank you, Judge.
All right. Anything else from the parties regarding this case?
We got off track a little bit. I want to make sure my client understands that he needs to stay on level 1.0 in order to be released.
You understand that, Mr. Edward?
Yes, sir.
You understand what the court expects?
Yes, sir.
All right. That'll be the order of the court. Thank you.
Thank you, Judge.
All right, we've got Mr. Garza next. Are you Mr. Garza?
Yes, sir.
All right, can you pull your chair a little closer to the computer for me? All right, my name is Judge Porter. This is a detention hearing to determine whether you should be released from detention or be ordered to remain in detention. You have the right to have this hearing in front of Judge Kim. You also have the right to have this hearing recorded if you want either of those things. Ms. Carter, your attorney, will let me know. Do you see Ms. Carter on the screen? She's the lady with the red hair.
Yes.
All right. All right. Ms. Carter, you requested this hearing.
Yes.
What's up?
Okay, well, Andrew's been in custody for a few days. He's on level 1. He is clean. I have known the family for about 17 years, as long as he's been alive. Well, 16. He's 16 years old, but I've known them for 17 years. He's never had anything before this court. There are no issues with this child ever before. That means school, that means in any situation at all. There are no discipline problems at home. There are no guns at home. And the gun that was in the car on the floorboard under backpacks, the police took. So he is not a threat to society in any way, shape, or form. And we're asking for him to be released before next. Well, we're asking for him to be released today, but definitely before next Monday.
Okay. Right, Mr. Garza, according to the police report, you were out a little bit before 2 in the morning on April 21st. Police conducted a traffic stop and they look on the floorboard of the car, find a scale in plain view in an open pocket of a gray backpack. They find 4.025 ounces of marijuana and a Glock 22 in the backpack. Numerous vape cartridges, cannabis oil, 65 individual boxes. Wow, that's a lot. So, Mom,
Yes.
what's Andrew doing out at 2 in the morning?
I have no explanation. I was asleep. I was in bed. I wake up really early to go to work every single morning. So
Does he have a driver's license?
he does. He has a driver license. I went to school and everything for it, or permission. It's a license.
Okay.
Mhm.
Does he have your permission to be out at 2 in the morning?
No, he
Does
doesn't.
he have permission to have guns in his car?
No, of course not. Of course not.
Do you have any idea where he got the gun?
I do not have any idea.
Do y'all have any guns in your house?
No,
So this gun didn't come from y'all?
no.
I take it y'all also don't have 14 ounces of marijuana in your house?
Of course not.
And I'm guessing that if y'all use vape pens, you don't keep stock of 65
No.
cartridges.
No.
Just a guess. Any idea where he might have gotten this stuff?
I don't. Again, I'm currently still working 2 jobs, so it's just me and my kids. He's the oldest. He helped me at the house, so I mean, I don't know where he would have got it or how it got in his possession.
Have you had a talk with your kids about this coronavirus?
Yes, I have.
And what's your position? Do they need to be out running around with all their friends, exposing themselves to possible bugs so that they can bring it home to you and make you have to take off work from both your jobs?
No, they shouldn't.
And what happens if you get sick and you miss work for both of your jobs?
I mean, I would have to stay at home, of course, and I mean, there would be a lot of other consequences, meaning financially and I mean, their health.
And so you're working to provide them with food and clothing and shelter, but he wants to run around at 2 in the morning, picking up who knows what other kind of viruses so they can bring him home and make you sick and endanger him and all his siblings. Is that what he's doing?
This was something that, I mean, it had never happened before. I had never had any issues with him whatsoever.
Do you want him home right now?
Of course.
So if I were inclined to release him today, and I'm not saying I'm going to do that because the gun scares me, but if I'm inclined to release him today, what are things going to be like at home for him?
Oh, he's in lockdown at home. That's for sure. That's no question about it. He's in lockdown at home.
So Andrew, you hear that you're on lockdown back in detention right now, correct?
What is that?
You don't get to go wherever you want. You don't get to drive around. You don't get to be with your friends. You don't get to play video games, right?
Yes, sir.
Okay. And so you're on lockdown back in detention, right?
Yeah.
And you hear what your mom is saying. You're going to be locked down at home if I'm inclined to release you, right?
Yes, sir, that is fine.
Would you rather be locked down back in detention or locked down at home?
Locked down at home with my mom.
Okay. Now, you heard me talking with her
Yes, sir.
about the bad consequences of you running around at 2 in the morning, right?
Yes, sir.
Okay. If you're out at 2 in the morning being exposed to who knows what, and you bring it home to her and you make her sick, what do you think is going to happen to you? Are you putting your house at risk? Are you putting your health at risk? Are you, your mom's working 2 jobs to pay for food for you.
I hear you.
Are you willing to risk that by repeating This going out at 2 in the morning?
Yes, sir.
You see why it's not worth it?
Yes, sir.
All right. Okay.
Judge, if I may.
Yes, ma'am.
I just want to let you know that the mom works for her family's business, so she can be very accessible and pretty much right on top of him most of the time.
I'm not worried about mom. I'm worried about Andrew making more bad choices because he's 16 and, you know, mom's out doing her dead level best to provide him with everything. And he's the one that's risking all of that. And I'm trying to get across to you, Andrew, it's not worth it.
I hear you.
Okay. All right. I'm going to release you, Andrew. You're going to be released on the electronic monitor. Here's the deal. You're on house arrest.
Yes, sir.
Okay. Until both your mom and your probation officer decide differently. Okay.
Yes,
You're not leaving that house unless you have permission of both mom and your probation officer. If either one says no, guess what? You can't leave the house.
Yes, sir.
Is that good for you, Mom?
Yes.
Okay. Yes. Andrew, what happens if you violate this condition?
I come back here.
Uh-huh. And are you going to get out after 6 days?
No.
How long do you think, if you violate this, how long do you think you should have to stay in before I consider whether or not to release you?
I wouldn't know. It's up to the judges.
Oh, no. I'm going to put this onus on you. I want a number. You break the rules. How long do you get to stay in detention next time? And it's going to be more than 6.
A month.
Okay. So you know what you're risking, right?
Yes, sir.
You break the rules, you're risking a month of detention. Is that what you want?
Yes, sir.
All right. All right, that's going to be the order of the court. Thank y'all.
Thank you.
Thank you, Judge.
Thank you.
Back to the front lobby. Miss Selena has one more here. Gutierrez.
I do. There you go. All right. Hold on just a little. All right. You, Mr. Gutierrez? Wait.
Hello.
Are you Mr. Gutierrez?
Okay.
All right. I need you to pull your chair closer to the microphone or to the computer. All right. My name's Judge Porter. This is a detention hearing to determine whether you should remain in custody or be released to a parent or guardian. You have the right to have this hearing recorded. You also have the right to have this hearing in front of Judge Kim. If you want either of those things, your attorney, Mr. Newman, will let me know. Mr. Newman, where are you? There you are. Okay. You have the right to remain silent and not say anything at all, unless that's what you want to do. If there's something you want to say, please do not blurt it out. Instead, I want you to wave your hand like this. You see what I'm doing? I will create a special internet chat room just for you and your attorney to talk about whether or not you really should say it. Okay? He can advise you. You can listen to him, and then you make the decision. All right? Okay. All right. Ms. Aguirre, am I correct? And this was the ice cream man robbery?
Yes, Your Honor.
All right. Working with 2 other kids, robbed an ice cream man, beat him up, took his money, allegedly. Apparently there was a gun involved and the victim got hit with the gun. And Mr. Gutierrez was subsequently identified as one of the robbers. Mr. Gutierrez confessed and also admitted taking part of getting the gun from a friend. Okay. Mr. Newman.
Yes, Judge.
What's your input?
Well, I would point out to the court that Mr. Gutierrez has maintained a level 1-0 since 426. Appears that he's taking this seriously. I'd ask that the court consider returning him to his grandmother's home. I think that would provide appropriate supervision. And going forward, I think he understands the seriousness of what he's done, having talked to him about it.
So he's been level 1-0 since yesterday.
I think he's moved a bit, but.
So he's been level 1-0 since yesterday.
Correct.
And he has been in here, good grief, 17 business days. Is that correct? So he's been in detention longer than
I think
17 business.
I think 17 calendar days. I think approximately 10 or 11 business days, Judge.
Okay. So 17 calendar days. All right. Ms. Farmer, what do you think?
Judge, we would be concerned with the safety of the community.
Right. At this point, Mr. Gutierrez, you've been back there for 17 days, and it took you 16 days to get to level 1-0. So I'm not yet convinced that you're serious about wanting to act right.
Your
Do you want
Honor.
to talk to your attorney privately? Mr. Gutierrez, do you want to talk to your attorney privately?
Yes.
Okay. Give me just a second. Okay. Mr. Newman, I'll ask you if you'll keep it kind of brief, because we do have.
Understood. Am I currently in a room with just you and the juvenile?
No, I've got to create the breakout
Okay.
room, but try and keep it brief for me, okay?
Understood.
Your Honor, may I say something regarding beneath those levels?
Let's hold on to that for just a second. Let's let Mr. Gutierrez, Mr. Newman talk for a little bit.
Okay.
Hey, y'all should be able to go in there now, Mr. Newman. Well, yeah. Okay. Are you Mrs. Avelar?
Yes.
Okay.
All right, Judge, I think we've concluded.
All right. Wait till he's back in the room. There he is. All right, Mr. Gutierrez. Based on the information before me, I'm going to order that you be detained. Here's what we're going to do. You are to maintain level 1O for 14 days, 14 calendar days, not business days, but 14 calendar days. We'll see each other again in 2 weeks, and I'll reconsider then whether or not to release you if you have maintained level 1O for that 14 days. You got me?
Yes, sir.
So you know what you got to do, right?
Yes, sir.
All right. Thanks, guys.
Thank you, Judge.
Unfortunately, it sounds like this level is where it needs to be.
All right. Are you Amoni Jamison?
Yes, sir.
All right. Okay. And are you Mrs. Jamison?
Yes, I am.
All right. Now, Ms. Alonso, correct me if I'm wrong. He is here on a terroristic threat of a family member or household. Is that correct?
Yes.
And y'all are currently working on a placement search?
He was already accepted to placement in Lake Granbury, and he said to go to court tomorrow at 8:30 in your courtroom.
All right. Mr. Jamison, I'm sorry, Mr. Newman.
Yes, Judge.
You think he's willing to hang tight for 24 hours and we'll revisit this tomorrow morning?
You know, obviously my client's interested in going home, Judge. I mean, that's been one of his goals since he got in there, so I don't want to overstep. I understand the court's position with regard to having a court date tomorrow. I do think we have the possibility of a deal. I'm going to hopefully work that out this afternoon with Mr. Boneberg and my client, if possible.
All right. And Ms. Jamison, are you know about the court hearing tomorrow morning?
Yes.
Okay. I think because we've got court tomorrow morning, I'd like to keep him tonight.
Yes.
And then we'll look at it, everything with fresh eyes in the morning. Is that okay with you?
Yes.
All right. Anything else from either side?
Nothing
Nothing from the respondent, Judge.
All right. You understand why I'm doing this, Mr. Jamison?
Yes.
Okay, because we'll have court tomorrow, and then we'll be able to look at everything tomorrow. But if I were to release you today, you might lose your place in line for placement. Now, I'm not promising you that I'm going to send you to placement, because I'll keep a completely open mind. I may decide to do something completely different tomorrow, okay? But if I were to release you today, you would lose your place in line for placement. And I want to keep that door open for you if that's appropriate. Does that make sense?
Yes, sir.
All right, I'll see you tomorrow morning.
All right, thank you.
Thanks.
Do I leave?
Oh, I didn't know. I'm sorry.
Thank you, Ms. Jamison.
Thank you.
You, Mr. Moreno?
Yes, sir.
All right, Mr. Moreno, can you pull your chair closer to the computer? All right, and I'm a little hard of hearing, so I want you to speak up for me. My name is Judge Porter. This is a detention hearing to determine whether you should remain in detention or be released to a parent or guardian. You have the right to have this hearing recorded. You also have the right to have this hearing in front of Judge Kim. If you want either of those things, your attorney, Mr. Newman, will let me know. Do you see Mr. Newman on the screen?
Yes, sir.
All right. I need to let you know you have the right to remain silent and not say anything at all. If there's something you want to say, please do not blurt it out. Instead, what I want you to do is wave your hand like this. This will get either my attention or your attorney's attention, and I will create a special internet chat room just for the two of you to talk about what you want to say. That way he can tell you whether or not you really should say it. Does that make sense?
Yes, sir.
All right. So, Ms. Lopez, Mr. Moreno was allegedly also involved in the robbery of the ice cream man. Is that correct?
Yes, sir.
Okay.
Judge, I do want to note, I believe these are separate incidents.
Oh, this is the
Yes.
this is the second ice cream man
Yes,
robbery. We have,
Mr. Moreno is about 30 days in for calendar days, and the other one occurred about 2 weeks. So
okay. I thought we had more than one. Okay. And this, let's see. So according to the police report, a Hispanic male in a red Ford Explorer pulled a gun on an ice cream man riding in the street. The victim did not want to surrender his belongings, so the actor reached into the victim's pocket, pulled out the quarters, approximately $100 in bills that were in the victim's pockets, and took the victim's red iPhone 11 before fleeing in the Ford Explorer. Officers later stopped a red Ford Explorer traveling around in the same vicinity, and a passenger to the vehicle was identified as Mr. Moreno. The victim subsequently positively identified Mr. Moreno as the person who robbed him with a handgun. All right, Mr. Newman, what are your thoughts?
Judge, my client's maintained level 1-0 for a substantial period of time. I think we're on about day 28 so far since he maintained that level. I think it may be appropriate and would be appropriate for this court to consider returning him to the home, as he's demonstrated he can follow this court's rules with whichever conditions the court feels necessary.
Right. Ms. Lopez,
Yes, sir.
what is his history with the department?
He's currently on probation till November, Your Honor, for evading with a vehicle. And another probation expired in April. So he is only on one adjudication probation now.
And what's he on probation for again? You tell me.
Evading with vehicle.
So, Ms. Farmer, he's already on probation for one felony?
Yes, Your Honor. It looks like he was placed on probation on November 26th of 2019. Based on him already previously been placed on probation, we would ask that he be detained because we believe he'd be a danger to himself and the community, given the violent nature of the offense.
Mom, what are your thoughts?
Well, I think he should be released because I know he's done bad in the past, but I know he's changed a lot. I can be there, you know, watching him. If y'all put him on the monitor, I really do want him to come out because I know he's going to end up doing some time when he actually goes to his actual court hearing. I think that they were talking about doing the placement for him. So I'm not sure if they're going to do that or not. But I do want him home, you know, for the remaining of the time until that court hearing comes. He's never been on the monitor before, so I think he'll do good on that.
Ms. Lopez, he was drug tested when he came in and he was positive for cocaine.
Yes, Your Honor, he was positive for marijuana and cocaine.
Oh, that scares me. Mr. Moreno, you're out there on felony probation, which means that's already been decided.
Yes, sir.
We have a victim who positively identified you as the one who had the gun. The probation officer's telling me you tested positive for cocaine.
I've never done that drug in my life.
Okay. Well, sometimes when you smoke marijuana, whoever gave you that marijuana could have laced it with cocaine because it's supposed to give you a different kind of high. So that's always the danger of accepting drugs from somebody you don't know, other than your doctor,
Yes, sir.
because they'll give you stuff that you don't know what you're taking. And
I would like to take a drug treatment like to TYRC to stop.
well, we're not here for that today. We're not going to make that determination today. Today is about whether you should be detained or released.
Yes, sir.
And what I have in front of me is not a same level of behavior, but increasing level of behavior and severity. And it scares me. It really scares me. And while Mr. Newman, your point is really well made in that he's been in 32 calendar days. He's maintained level 1.0 since March 30th. And you've got a real good argument that normally, if he weren't already on probation, and if this wasn't a gun offense, yeah, I'd cut you loose without a heartbeat. But this just scares me.
Sir,
This scares me. Plus the cocaine scares me. And I'm just afraid that if I cut you loose today,
Well, sir, he's gonna be under my supervision. I know for a fact that, well, now I'm not working. Now I'm gonna be able to be there 24/7.
I understand, Mom. I really, really do. But he's 14. This scares me.
Yeah, but those are like the past violations that he had, like.
No, Mom, this is 30 days ago. This is 30 days ago. Let's don't minimize the conduct.
Yeah.
I mean, the marijuana, the cocaine, that's 30 days ago. That's recent. Okay? Let's don't minimize the conduct.
I'm clean now, sir.
Well, I'm going to give you a little bit longer to get a little cleaner, okay? Because I'm not inclined to release you today. So I'm going to order that you be detained. We'll reconsider this in 2 weeks. You maintain level 1.0 for 2 weeks, and it gives me even stronger reason to reconsider this decision, but I'm not comfortable today.
So I'm gonna see you in 2 weeks.
Yes, sir, you will.
Okay.
Unless your attorney wants to have it in front of Judge Kim, but you'll see me again in 2 weeks, and I'll reconsider it with an open mind then.
Yes,
all right?
All right.
Yes, sir. Thank you.
Thank you.
Thank you.
Judge Porter, I got dropped off because of an internet problem and I'm back, but sometimes you're cutting in and out. Are you able to hear me clearly?
I can hear you great.
Thank you.
And are you Mr. Roca?
Yes, sir.
Do you pronounce it Roca with the CH being a hard K sound?
CH is like ch, rocha.
Ch, so Rocha?
Yes, sir.
All right, I can do that for you. And are you Mr. Rocha's parent or guardian?
I'm his mother.
All right.
Yes,
And are you Miss Ingram?
I am.
Okay. So, Mr. Rocha, my name is Judge Porter. This is a detention hearing to determine whether you should remain in detention or be released. You have the right to have this hearing recorded. You also have the right to have this hearing in front of Judge Kim. If you want either of those things, your attorney, Mr. Newman, will let me know. Do you see Mr. Newman on the screen?
Yes, sir. I see him.
All right. You also have the right to remain silent and not say anything at all. If there's something you want to say, please do not blurt it out, okay? Instead, what I want you to do is I want you to wave your hand like this before blurting it out. That'll get my attention. That'll get your attorney's attention. And I'll create a special internet chat room just for you and your attorney to talk.
Okay.
That way he can advise you about whether or not you really should say it. Does that make sense?
You say.
All right. And let's see. Mr. Neba.
Sir.
What brings Mr. Rocha to court today?
Well, Jelly Rocha was referred in custody back on the 12th of April for PD for aggravated assault with a deadly weapon. Officers arrived at around 11:40 hours. When they arrived, it was a domestic disturbance involving Jaleo and his father. The father is the victim in this case, who alleged that Jaleo hit him several times with a stick. Wooden post, approximately 4 feet in length, 1 inch in diameter. His left hand might be broken, and medical attention did show that it was broken. Officers could observe red bruising and swelling on the hand, inner left forearm, on the shoulder. He advised that Jaleel got mad after he told him that to clean the garage. Father had to hold Jaleel down because Jaleel was throwing things around, and then he let him go, and that's when Jaleel grabbed the stick and hit him multiple times.
All right. Miss Ingram, how's Dad doing?
His dad is doing well. He's recovered quite nicely. He's a methodic vitamin taker, so he's recovered really well.
And broken bones, anything like that?
I think it was more of maybe some soft tissue damage and a sprain, but it was very discomforting at first.
And I don't know if you've seen all the tattoo work that Mr. Rocha has. Do you know about that?
Yes.
What are your thoughts?
The last one, he did that because he had got away from us again. This is why the police kept getting called. And this is new on his hand. I didn't know about that one because he had ran away, and I seen that on Instagram.
So he has a pattern of running away?
Yes, he does.
Okay.
From us.
Now, if I were inclined to release him, I would be releasing him to you. Do you understand that?
Okay.
And it would be your responsibility to make sure he gets back to court.
Okay.
If he doesn't make it back to court, 2 bad things could happen. First, I'll issue a warrant for his arrest. That makes sense, right? Because he didn't show up when he was supposed to. The second bad thing concerns you. I could actually issue a warrant for your arrest because you didn't make sure he came back to court.
Oh, but what if he gets away from me?
It's still your responsibility.
Okay.
To make sure he gets to court.
Okay. Okay.
So given his history of running away, I'm going to guess, we've only met for about 30 seconds, right?
Indeed. Yes, sir.
I'm going to guess you probably have not spent a lot of time in the Tarrant County Jail, right?
I have not. No, sir.
And so I'm going to guess that that's not really a place you want to go, right?
I really don't. I'm about to become a grandmother.
So, given Mr. Roach's history of running away, is he really worth taking a risk on you going to jail?
Oh my goodness.
I'm going to guess the answer is probably no. Mr. Rocha, do you need to talk to your attorney privately?
No, I don't need to talk to him privately. I'm just like, if you do release me, I wouldn't run away.
Your history says otherwise.
Yeah. I just wanted to put that out there.
I appreciate that, but you understand actions speak louder than words, and I have to look at not just the present, but the past.
Yes, I do.
And you understand how your past doesn't look too good for you, right?
Yes, I do.
And so, Ms. Ingram?
Mm-hmm. Yes, Your Honor.
You think he needs to spend a little longer in detention to make up his mind?
My heart just, because he's my baby. So
yes, he is.
I just want him to do the right thing. And I think this is a wake-up call. And if he knows that my butt is on the line just as well as his, I hope that he would do the right thing, because he knows that I have a lot. I have a career. I have kids. So Jalil knows.
Yeah, okay. But you said something there, and I'm going to repeat your words. I hope he would do the right thing. There's a difference between I hope he'd do the right thing and I know he'll do the right thing.
And
there's
Indeed.
a whole lot of wiggle room between, right?
Yes, sir.
And before you really need to put your arrest record on the line, that hope really needs to be closer to the he will do the right thing, right?
Yes, sir.
So how far apart are we? Are we here or are we here? Because it sounds like we're over here.
Your Honor, I am a woman of faith, and I do believe that everybody deserves a second chance. And
I agree. I agree.
And because Jalil has gotten this experience, I think he really, I do believe that he really is ready for change and vindication, because he has a lot to prove to not only himself, but to his family as well.
How many times has he called and talked to Dad since he's been in detention?
He's talked to his dad, I believe, twice.
And how does his dad feel about him coming home?
His dad was actually very excited about him coming home. The reason that he's not here this morning was because he works third shift.
Oh, okay.
Yes, sir. He works nights and I work days.
Do y'all approve of all of these tattoos he's getting?
No, sir, we do not. Those were while he was out of our reach when he did that.
And just have y'all had a discussion with him about how those tattoos might impact his employability?
Indeed.
Should he ever want a job?
Yes, Your Honor. He actually has, you know, he's been working at Taco Bell, and that was a blessing that he got that job.
But if he ever wanted a job at, let's say, Lockheed or Boeing or General Motors, if your husband's the one that's doing the hiring for those things, we've got a kid who comes in a clean white pressed shirt and a tie and some slacks and no neck tattoos. And then we have your son who comes in a t-shirt and jeans. Who's your husband going to hire?
The first one.
Okay. Have y'all had that discussion with your son?
Yes, Your Honor, we have. We genuinely have had that conversation. Indeed.
Okay. Mr. Newman?
Yes, Judge.
Any other thoughts?
Judge, I would just point out what I've been pointing out in some of the other cases this morning. My client made level 1 at the first opportunity he had. If you look at the offense report provided by the probation department, his admission date was 4/12. 3 days later, he made 1-0 and has maintained it since. I'd also point out to the court that there's other mitigation efforts that this court could make. That would be the ankle monitor with GPS tracking. I know the court may have some difficulty trusting my client, but trust but verify might be a good premise for this court to undertake in this case. I think that he's ready to go home in my conversations with him.
Ms. Farmer, what are the state's thoughts?
Well, Your Honor, we'd like to point out that he tested positive for marijuana on 4/10. We're also concerned with the fact that he could abscond. I know his mother is keeping the faith, but based on his history, it looks like that is a possibility. And based on the drug use, if he were to abscond, we'd be worried that he'd be a danger to himself.
Ms. Farmer, I am likely to agree.
And Judge, may I clarify? I don't have any report related to any drug use. And I will note from the information I've received that he would not have been before JPD at any point on the 10th of April. So I wonder if the wires might be crossed, because he has no prior history with this court and his admission date and offense date are 4/12.
All right, Mr. Neva, has he been drug tested?
No, sir.
And Judge, I do apologize. Mr. Newman is correct. I was looking at another respondent's offense report. It does not appear that he tested positive for marijuana. I do apologize.
Okay, all cleared up. Mr. Neva, he has no prior history with the department, is that correct?
No, sir. This is his one and only referral.
All right. Mr. Rocha.
Yes, sir.
I don't like the fact that you came in to the underlying aggravated assault. But if mom and dad are both excited about the fact that you might come home today, if they have faith in you, I'm going to take a chance on you. However, I'm going to release you on electronic monitor, which means you are essentially on house arrest. You can't leave that house without the permission of both mom, not dad, mom, and your juvenile probation officer, Mr. Nava. They have to both give you permission before you're allowed to leave that house. You got me?
Yes, sir.
Okay. So electronic monitor, and then we'll revisit this whenever your underlying case has been scheduled for court. Okay?
Yes, sir.
All right. Good luck. Stop getting tattoos.
Thank you.
Thank you.
All right. Well, Mr. Kroll was here. There he is.
Morning.
Morning, Mr. Kroll. Hey, are you Mr. Sales?
Yes.
Am I pronouncing your last name correctly?
Yes, sir.
All right. My name is Judge Porter. You have the right. This is just a detention hearing to determine whether you should remain in detention or be released to a parent or guardian. You understand that?
Yes, sir.
You have the right to have this hearing before Judge Kim. You also have the right to have this hearing recorded. If you want either of those things, your attorney, Mr. Newman, will let me know. You see Mr. Newman on the screen.
Yes, sir.
Is that a yes?
Yes, sir.
Okay. Now, you also have the right to remain silent and not say anything at all. If there is something you want to say, please do not blurt it out. Instead, what I want you to do is I want you to wave your hand like this until I see it or your attorney sees it, okay?
Yes, sir.
I will create a special internet chat room just for you and your attorney to talk about what you want to say. That way he can tell you whether or not you really should say it. Does that make sense?
Yes, sir.
Okay. And let's see. Are you Miss Cunningham?
Yes, sir. Yes, I am.
Okay. So, Mr. Kroll, what brings Mr. Sales to court today?
On 410, Mr. Sales was referred in for a burglary of a vehicle. At that time, when he was brought in, he tested positive for marijuana, and he was pending court for UUMB as well as evading arrest, and the evading was on foot.
Okay. So he's got a new BOV alleged, plus he's pending on a UMV?
Correct.
Okay.
So I would like to add, I have not discussed this with the mother or client at this time, but the mother was, or they did get him into TYRC outpatient as recommendation. The mother followed up with TYRC after his first detention hearing, informing them that he continued to use and test positive. TYRC did contact me today, this morning, as well as the other day. They are willing to accept him inpatient as an option.
Inpatient or outpatient?
Inpatient.
How do you feel about that, Mom?
I don't know. How does he feel about it? This is the thing. I don't know. I really want him home, but I really want what's best for him, because the thing is that Quentin needs to understand that he can't go around taking things that don't belong to him, because that's not what or how we raised him to be. We've been doing the counseling thing, but since when this happened, it interrupted that. So then when the COVID virus situation happened, we were trying to do the thing online. So I have still been doing my parent counseling thing on the side, but he has been missing his because of course he's been here. I've been looking at other options myself. I thought about the Texas Cadet Academy that I was trying to get him in to help him out. I've also, you know, got some friends that were gonna like work with him at the mechanic shop. We had some things that need to be cleaned up there, you know, try to mentor him some. Purchase an old car that has nothing on it, and we were gonna try to teach him to fix it and run it. We just wanted, you know, he's a good kid. This kid taught himself how to play piano, read notes, plays the drums. Like he's got all this potential, and I just don't want him to throw it away. So I mean, like if inpatient works for him, I mean, maybe we can consider it. I don't want him to be somewhere that's gonna make it worse than what it is. But so that's pretty much, you know.
Mr. Newman, it sounds like you have a really great parent here to work with. What are your thoughts?
Well, Judge, I've spoken with my client. His desire is to go home. He's under the belief that he can show this court and his mother that he can do better. Certainly, the developments from Mr. Crawl is something I will have to discuss with my client because, you know, in my opinion, generally that's always a good opportunity for my clients. And so that's certainly something I'd like to discuss with him. I think given the fact that he has no adjudications before this court, and you know, this court could consider releasing him, given that he's maintained level 1-0.
Mr. Crawl, if he's supposed to go to TYRC inpatient, it's easier for him to go if he goes straight from detention, correct? Or does it matter?
So no, what I was contacted with last was that they would have to pick him up because of their quarantine rules. So with him being in detention, they would pick him up and transport him over there. So if he was out in the community and tried to go, I'm not sure what that quarantine looks like.
Yeah, if he was out in the community, everything would be done in-house. I have everything set up with group meeting and all that with his counselor Sam, and then with mine. So everything is pretty much set up that way if he's at home, because right now we're not doing face-to-face right now inside of the...
Right. The only way he can go to, it's my understanding, the only way he can go to inpatient right now is to go straight from detention to inpatient.
And Your Honor, just one last thing I'd like to add. This is his only stay in detention this current time. Prior, he was brought in and released him off.
Yeah.
I just want to say one thing. This kid is not a broken kid. This kid has a lot of support.
You're exactly right.
He has a huge village. He has a father that loves him, that's involved. He just couldn't be here today because he couldn't get away from work. Grandparents that's involved. He has brothers and uncles that's involved. I even have my friend that's willing to put up, you know, and have him working at the mechanic shop to teach him new skills. They're even actually, like right now, it's a lesson. This is a lesson for you to learn because you have all this opportunity. You want to go to Grambling University. How can you go to Grambling University if you have a bad background? How can you do all the things that you want to do if you bring yourself back here? See, these are the lessons that I told you before you even could step foot in this place. This is what I was trying to keep from happening to you. And it seems like you had to taste it for you to see it for yourself. How does it taste? Does it taste good?
No, ma'am.
No, it does not. And this is the thing. We love you. We want everything best for you, okay? You got good parents here. We co-parent at its best for you. You know what I'm saying? You're not the only kid. We have other kids that we have to raise, and they look at you. You see what I'm saying? This is the thing. All I want you to do is do better. You're smart. You have everything ahead of you. There's no reason for you to surround yourself around negative people. It's so easy to walk away. Your brother does it to you all the time. Your 14-year-old brother hangs out with you, and when he senses something ain't right, why does he always beat you home, but you never come home? You see what I'm saying? You see the difference there? You know, I need you to understand that. See, you come back home, you can't be sneaking out of the house and doing all these things. There's nothing for you out there to steal. You got everything you want at home. everything you want at home. And so this is the thing. I mean, if he has to end up doing the outpatient thing, then that's the punishment thing, and that's the consequences that Quentin has to deal with, because Quentin put himself there. We didn't put Quentin there. The thing is that I had something lined up for him that I thought would help, because it seems to me that this kid does a lot more better with discipline. And that was to set him up with the mechanic shop, because we got a whole bunch of tires that need to be moved. It's a bunch of things that need to be cleaned up, and it's a bunch of lessons that I felt like he can learn. He can actually earn a paycheck out of it, but it's a lesson first out of it. You got to prove yourself first before you can learn a paycheck. We even purchased a car, $500 for a car with no shell in it, just to teach you how to put things together. If you want to steal cars, why don't you build this car up? You know, learn something. I was a mechanic for 13 years. I picked myself up. You can do the same thing. Got a lot of potential in you. You know what I'm saying?
Yes, ma'am.
Because none of them friends that was hanging out with you when you got in trouble, ain't nobody called to ask to see if you were okay. Ain't nobody asked how you doing. You see, don't nobody care about nobody but themselves. Quentin, you need to worry about yourself. You got a bunch of homework that needs to get done right now. We need to catch up on. See, the plan was if he got out of here with me, he was going straight to his father's house because he's going to stay there for a week. And it was just all straight catch up on the online homework and stuff he has to do, because I've been in contact with all of his teachers and everything else. So they know you're here. I contact everybody. So all we have to do is just make the decision on, it's you, it's your choice, and the judge and everyone else's. But, you know, that's all I have to say, Judge. I just wanted you guys to know that, you know, this kid is well loved. And, you know, the mistake that he made, he did call me. He apologized. He did tell me, Mom, I apologize for the things that I've done. I know that I was wrong. And I know that what I did was wrong, because I didn't have no business being outside. These were his words. And I didn't know that if somebody coached him that, you know, and I told him, well, thank you, son, for calling me and, you know, and telling me that. You know what I'm saying? And he did tell me that the words that I tell him, you know, all the time is, you know, that he, you know, I'm right. I know I'm right. I just try to keep you, you know, out of that. That's all we want. I love you.
Me too, Mama.
Okay.
Mr. Sales, you don't know how lucky you are to have a mom who is so committed to you. We basically have a choice. We have 3 choices here. I can keep you in detention, and we'll see each other again in 2 weeks. I can keep you in detention, and you can ask me, or you can agree on your own to go to inpatient treatment at TYRC. Or third option is I release you to your mom, and you go home and you start all these services, and we revisit the issue of inpatient treatment at a later date. Only you can tell me whether or not you're really ready to go to inpatient treatment.
I can speak now.
Yes, sir.
I will want to get released and do my service time, do work on my mama and work on myself, and so I can show you that I can be a better person and not come back inside of here. And also do, if I have to, do the inpatient and show that I can stay off of THC, stay off of marijuana, and do better.
All right. Mr. Sales, I'm going to give you a chance to prove yourself, because I have full faith in your mom and I have full faith in your dad. The only one I doubt right now is you, because we've let you out before and then you ended up back here again, right?
Yes, sir.
So the only one I doubt is you in this equation. You tell me you're serious. Your mom has gotten all this stuff lined up just for you because she loves you and believes in you. And you're telling me you want to give that a shot, okay? Yeah. I'm going to give you that shot. Here's the deal, though. Last time we let you go, you ended up back here. If I let you go this time and you end back up here, there should be some consequences, right?
Yes, sir.
Okay. So you've been in for 16 days, right?
Yes, sir.
So if you go home and you don't follow through with everything that you just promised your mom, because you promised your mom you'd do all this, right?
Mm-hmm.
If you break her rules, you go out and you commit a new offense, allegedly, and you wind up back in detention. Instead of 16 days in detention, how long should you stay in detention next time before we consider you for release?
2 months.
2 months?
Yes, sir.
Okay. So now that's what you agreed to. So now you know what you're facing if you don't follow your mom's rules, right?
Yes, sir.
Am I going to see you again?
No,
Back
sir.
in detention?
You won't.
All right. Am I going to hear about you testing positive for drugs?
You won't.
Okay. You're going to be able to stay straight and narrow.
Yes, sir.
All right. I'm going to give you a chance, Mr. Sales. I'm going to release him on the electronic monitor.
Yes, sir.
I
agree.
Do you, both you and your his dad live in Tarrant County?
Yes, sir.
Great. Then we won't have a problem with the electronic monitor. If he goes to live with Dad, make sure that Mr. Kroll knows that, and
Yes,
that if he's going to come back to live with you, make sure that you all tell Mr. Kroll the same day that he goes back. That way there's not an electronic monitor violation.
Yes.
And if he is going to go work at that mechanic shop,
You let Mr. Crawl know, correct?
you gotta arrange that with Mr. Kroll.
Okay, we will.
Because if you don't, it's going to be an EM violation, electronic monitor violation.
I'll have the friend call and the owner of the shop call and set it all up and let him know like what days he'll be there and stuff like that. Because it's going to be strictly drop off and pick him up. It's not, it's no hangout. It's definitely no hangout. They're really ready for you.
All right.
We got
All
some
right, that's
on wax off in to do.
Thank y'all. That's
Thank
going to be
you.
the for the court.
Thank you.
All right, Mr. Zavala. We're going to do that one last because I got to close off the court. Are you Mr. Oh,
Oh, I'm sorry.
Okay.
are you Mr. Zavala?
Yes, sir.
All right. And are you Mrs. Barron or Baron?
Yeah, Baron.
Barron? Okay. Okay. Ms. Rodriguez, can you hear me okay?
Yes, Your Honor.
And Mr. Zavala was brought in on the alleged aggravated robbery of the ice cream man. Is that correct?
Yes, he's the companion to the first trial that you heard earlier.
Correct. Well, not the very first one, but I believe it was Mr. Gutierrez. Is that correct?
Correct.
Okay. Now, there you are. Mr. Zavala, my name is Judge Porter. This is a detention hearing to determine whether you should remain in detention or be released to a parent or guardian. You have the right to an attorney, and you see Mr. Youngblood on the screen. You see Mr. Youngblood on the screen?
No, sir.
Okay.
I don't see him either.
Can you hear Mr. Youngblood?
Yes, sir.
All right. Have you spotted him on the screen yet?
That was him that just came on the
It
screen.
says Edwin. Okay. Now, you have the right to have this hearing in front of Judge Kim. You also have the right to have this hearing recorded. If you want either of those things, Mr. Youngblood will let me know. You also have the right to remain silent and not say anything at all unless that's what you want to do. However, if there's something you want to say, please do not blurt it out. Instead, what I want you to do, I want you to wave your hand like this. That'll get my attention, and that'll get your attorney's attention. And instead of you just blurting it out, I'll create a private internet chat room just for the two of you to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
All right. You heard me talking with Ms. Rodriguez, and the reason you've been back in detention for a while is because of an alleged aggravated robbery of an ice cream man. Ms. Rodriguez, he's currently level 1-0 in the back, right?
Correct.
And does he have any prior history with the department?
No prior history.
And he's not been drug tested, correct?
Correct.
However, according to the police report, the police report says that Mr. Zavala was the one who took the gun and hit the victim in the head with the butt of the gun. Is that correct?
Correct.
All right. And this happened around 6:30 in the evening. Mom, do you have any idea where Daniel allegedly got the gun?
From what I've been hearing, he got it from some kid named Angel.
Do you know this Angel?
No, I don't, sir.
Do y'all have guns in the house?
No.
And does it scare you that your 15-year-old can just get on the street and find a gun?
Yes.
Scares me too.
May I interrupt, Judge? It's not a whole lot less scary, but this is a BB gun. Still could be used as a deadly weapon if you hit somebody with its butt.
So this was a BB gun pistol, allegedly?
Correct. Yes, correct.
Okay. Well, actually, Mr. Youngblood, that does change the calculus. It does move the needle in your favor slightly.
I'll take what I can get, Your Honor.
All right, Mr. Zavala, you understand that this court takes guns and kids very seriously, right?
Yes, sir.
Okay. And you heard Ms. Rodriguez say this is the first time you've ever been in detention that we know about, right?
Yes, sir.
And Ms. Rodriguez, he has been level 1-0 since when?
Since April the 13th with no infractions.
With no infractions?
Correct.
How many times a week do you see a kid maintain more than 10 days with absolutely no infractions?
Rarely.
What does that suggest to you?
He can follow the rules.
Okay. Mom?
Yes.
It sounds like he can follow the rules in the back. What kind of rules would he have at home?
He has rules at home. He does what he's supposed to. It's just the wrong kids that he hangs around with.
Well, we heard from Mr. Gutierrez earlier, and Mr. Gutierrez blamed Mr. Zavala as being the bad influence. But now I'm hearing that Mr. Zavala is blaming Mr. Gutierrez as being the bad influence. Who should I believe?
I mean, I've known Mr. Gutierrez for a couple of years. They've always hung out. I've never had an issue with him. It's the older kids.
And do you know the other kid that was involved in this?
No, him, from what I know, he's in high school. And I don't know who he is.
Ms. Farmer, what says the state?
We would defer to the court on this one, Your Honor.
Okay. Mr. Youngblood, convince me.
Well, Ms. Farmer knows more about this than do I, because I don't have much to go from. And what I have is from Ms. Rodriguez. But I believe that there are 2, maybe 3 other people that were not apprehended on this, which doesn't, of course, excuse either Mr. Gutierrez or my client, Mr. Zavala, from actions if they took them. However, it is likely that some of these suspects, from what I'm hearing, are adults. And what Mom just said is she feels like the adults are leading both these boys astray. As you pointed out earlier, last time I had a client who was in detention as long as this one has been without any problems at all. And so I would encourage the court to consider releasing him with strict location information, maybe a monitor, and certainly no contact with these other boys, whoever they are, or young men, if that's who they are.
And Your Honor, I just want to make sure you're aware that he was living with grandma when this occurred, and mom lives in Louisiana, but she's in the process of moving back to Texas next month.
Okay, Mom, when are you supposed to be back? And where are you moving back to Texas?
I'm moving with my mom until I get a place. But I'm in the middle of May.
Okay, and Mom lives in what county?
New Orleans, Algiers.
Grandma in Fort Worth.
So you currently live in New Orleans?
In New Orleans.
And the grandmother lives where in Texas?
Here in Fort Worth, North Side.
Okay.
May I inquire, Mom, how long are you going to be here in Fort Worth? Are you going back to New Orleans and then returning here, or are you staying here?
No, I'll be going back when I move back in May. When I move back in May, is permanently. I'll be staying here for good.
Understood that, but when do you return to New Orleans?
Wednesday, I believe.
And when will you be back?
In the middle of May. I want to say.
How old is his grandmother?
How old is grandma? She's 54, I believe, if I'm not mistaken.
Does she have any kind of physical disabilities, or is she able to keep track of him and discipline him?
She has high blood pressure that I know.
Okay, but she gets around fine. She's not on a cane, or
okay. No, she gets around fine.
And as far as you know, is she willing to undertake taking care of him in the meantime? And that probably means watching him like a hawk.
Yes, she is.
Thank you, Your Honor.
Okay, you understand I can't let him go out of the state.
Oh, I know. That's why I was coming back. I was coming back home.
And you told me that he was in grandmother's care when this allegedly occurred.
Mm-hmm.
So that gives me some concern of whether or not he's really willing to obey grandmother's rules. You understand?
Yes.
That's why I was suggesting the monitor if you release him, Your Honor.
On the one hand, I've got a kid who has maintained level 1.0 with no infractions for basically 2 weeks. On the other hand, I have a victim who was just scared for his life, who thought he was going to get killed. and I'm being asked to release Daniel to the same grandparent that he didn't listen to the first time. Mr. Zavala?
Yes, sir.
I'm sorry. I'm not comfortable releasing you right now. I'm not. I just go back to the police report that says where you confess to being part of the robbery and that you confess to being the one who hit the victim in the head with the gun. Even if it was just a BB gun, that's just a little too serious. I just don't feel comfortable right now releasing you. Here's what you're going to do, though. We'll revisit this in 2 weeks. You'll have another detention hearing in 2 weeks. If you can maintain level 1-0 without any additional infractions for those 2 weeks, you're going to make a strong case for me to release you in 2 weeks, okay?
Yes, sir.
But since you were the one who admitted to hitting the victim with the gun, I can't do it today. It's too recent, and that's just a level of involvement that's more serious, and I just can't do it right now. I'm sorry. So I'm going to order that you be detained, but we're going to reconsider it in 2 weeks, okay?
Mm-hmm.
All right, that's going to be the order of the court. Mr. Youngblood?
Sure.
I'll be honest with you, I was very close to releasing him, but it really was the gravity of his involvement in the offense. But I do mean it when I say I will keep an open mind in 2 weeks.
Yes, sir. It would be a big help if Mom was back, I'm sure.
Yeah, it would. Thank you, sir. Okay, and then, all right, the only respondent we have left for today's detention hearings is under 14. So pursuant to section 54.08 of the Texas Family Code, I am going to be ending the YouTube broadcast